52, 52.
46.
46.
46 after 2 weeks.
So you're for current. 22, 22, 11. 211.
14.
40. For appellant, Amma,
Yes.
other side inform chesara.
Yes, we have it. Speak of this.
52 appeal hai kada. 13-12.
52 to 66.
Item number 61 and 62 are connected. Next week. Next few weeks.
Appellant.
These
22,
claimants have been other things.
22, 11.
67 to 75.
Lordship, item number 67, Lordship. Value posted 2 weeks earlier. Here comes the first
22, 11.
70, 22.
70 కూడా 22, 11.
76 to 86. 87 to 94. Daily list for dismissal items 1 to 14. Sandhya Somorapu, Mahbub Hussain, G. Malasi.
Ready?
In this case, clear. Can I request you to pass?
Right. I'll hear all the matters at once. Awesome.
Today.
Ask him to come early.
Yes.
No, after a while.
Yes.
Munde rammanandi. After lunch kaadu munde rammanandi.
Yes, yes.
Item 15. Alluri Raghurama Aurava and P. Venkatram Reddy.
Responding to Girish case.
No representation.
Manpreet Kumar. Yes, ma'am. Dismissal cash.
None appeared for the appellant. This matter was listed. $18 కాదండి 16. 13 no, there was no representation. It was ordered, it was listed on 4/10/23 without any representation.
Item 17. K. Jamali and Mohammad Shafiuddin, Mohammad Mujahid Qureshi.
No representation for the appellant.
P. Rajivan and P. Vidyasagar Reddy.
This is an appellant.
Yes.
Appellant 500 for partition, partition for dismissed. That I first of all, my argument is the lower court counsel did not cross-examine the defendant, and also family settlement exhibit A1 was marked. And that was also sent to private handwriting expert, and they got order that it is a wholesale document. And The counsel also did not appear before the court and did not cross-examine defense D1 and D2. Is all my submission.
Then how can we cure that defect?
Yeah,
Still
my only taken in the ground that by mistake of the advocate party should not further solve my argument. And also, I am saying this, if the chance is given for remand, I will do it also.
I had counsel for the appellant, now represented 2811 for pronouncement of
For admission, item 19 and 20. Kottate Rambabu and Praveen Kumar Virdala. Here are in the red.
none appeared for the appellant. 2nd January. None appeared for the appellant. Last week of January. The list of the 23 FP. ఉన్నాయా అలా అయితే మంచిది మనమే డేట్ ఇద్దాం 22 Jan.
For further hearing, item 21, Ali Faruqi and Saroj Ram Bastawala.
చూపిస్తున్నారా పేపర్ బుక్ వేస్తాను ఏమన్నా వేసాడా లేదు
Item 22, KV Bhanu Prasad and Ajay Kumar Madishetty.
For the respondent.
I appear for the appellant in this matter, revision petitioner, my lords, representing KV Bhanu Prasad. The open petition has been filed, my lords, by the respondents.
Yes. You filed revision.
And if I think open along with the counter.
What do you say? You have any objection or shall I allow the reopen petition?
Your lordship may reopen it, my lord. Lordship may fix a date for a hearing, but the senior counsel has asked to represent.
Respondent, I allow. Reported no objection to reopen the matter. IA is ordered. May no CRP law in view of
On 15th, senior counsel has some difficulty.
1711.
17 minutes, I'm obliged.
Admission item 23, V. Sambashwara and J. Pramod Gaur.
The complete by the insurance company. Amendments also filed in Marathi in 1333 of 2019.
Our counsel for the appellant. Is there any delay, sir?
No delay.
Admit. And list the appeal along with MSCMA 1333 of 19
2009.
on
MS 1333.
6/12. Done. Connected. Dismissed.
Some traffic jam.
Dismissed. And if you are ready to argue, I will consider. 17. Yes. Sir. Because you were not ready for the past 5 adjournments. Right, you are ready. Go ahead. Still you are not ready. Yeah, how can you say that, sir? I do remember what was happened on the previous dates. You are continuously asking an adjournment and considering your request, this matter has been adjourned from time to time. Also, it's
Item 24. Hari Prasad.
counter in.
There is an idea of additional evidence by the lunch. In that idea, I have to file counter. I have to file counter. 2 weeks pending.
It was not admitted. Still was not admitted. Additional evidence petition can be considered if the appeal is admitted. For admission, you need not file counter in the IA.
What happened for the document which was filed that was not done in
Counsel for the respondent start time as you want to file counter in IA1. IA1 to no representation for the appellant. 1511 under the caption for dismissal.
Item 26 and 27. M. Rajit Kumar and K. Siddharth Rao.
Yes.
Correct. Maybe I can draw my Lord's attention to event. When it can go to the root of the issue.
You are arguing IA1 of 20. Yes, state petition.
Page number 16. I'll highlight a handful of events. That is the page number 16. Part number 3.6. Being agreed by the including the demand notice dated 4/3/2022 within bracket received by the appellant on 24/5/22. This is the root of the issue. Total both the cases. Next, I'll draw my Lord's attention to page number 18. Next page. There are a couple of events. Limitation. Notice of demand notice dated 4/3/22 within bracket served on appellant on 24/5/22. Cause of action 24/5. Prayer. Even again it is dated as 24. But I'll draw my Lord's attention to page number 51. Certified copy, top left hand column. Received on 24/5/2022. Signed by petitioner. With the implemented which the petitioner applicant. But I'll draw my Lord's attention to orders passed by the lower court. Page number 1.
Page number
10. Page number 10.
yes.
Paragraph number 9. Appreciation of evidence on record. Correct. As per the documents produced by the appellant, it shows that the respondent corporation fixed the property tax regarding the schedule so and so as per the assessment of property of the tax history. The next two sentences are important. We will go to the root of the issue. On the other hand, it shows that the bill collector served the impugn demand notice to the appellant on 4/3/22.
Is it 4-3?
Yes. I draw my lord's attention to page number 51, which is the notice of the challenge. Page number 51.
According to it was for 24-5.
Exactly. And the endorsement is on top right hand corner by the petitioner appellant here. Third one. Thereafter, notice dated 4/3. Why document number 5? The lower court considers it. That is page number 15. The appellant filed the present appeal before this court on 6/6/20. 6th June 22. This is at page number 27. The docket shows it is part. And challenge the internet copy so on and so on. Next sentence. On the other hand, it shows that respondent establishes the appellant received the original demand notice issued by the respondent corporation 4/3/20. My total case is that the petitioner appellant received the notice on 24/5, wherein the lower court failed to consider my presentation. This is a document which he has considered while passing the impugned order. As such, give the honorable court the all for further proceeding under the. This is the only issue, nothing more.
My instructions, Your Lordship, and we have also filed the notice in our counter, Your Lordship. It was served on 4/3 and not 24/5, Your Lordship. The notice dated 4/3 was served on 4/3 itself, Your Lordship.
What is the proof you have tried to show that the same was served on 4/3?
Lordship, we have in our counter we have filed the original notice which has been given to the appellant, Your Lordship. It says dated 4/3/2022, Your Lordship. One more aspect, Your Lordship, I would like Your Lordship to look into the order of the lower court, Your Lordship.
What about the photocopy filed along with the counter, which shows that the receipt was served on 4/3?
Which the lower court relied upon. This
No,
it is not
they have filed the copy of the
It
notice.
is not signed by me, it is not received by me. Your
Lordship,
signature is
Lordship may see the serial number filed by me and serial number filed by the appellant. It is the same serial number 27. It is a copy of the same receipt book. It is copy of the same book, Your Lordship. That may be written afterwards after receiving after it was received by the appellant, Your Lordship. We are not aware of that because it is the receipt from the same book. The receipt number shows the same thing. The amount shows the same thing. Everything is the same, Your Lordship. The notice is actually in a slip, Your Lordship, which is torn and one slip is given with us and other slip is given to the appellant. That may be written, that is disputed, Your Lordship. That may be written by the appellant himself, Your Lordship, and the lower court has rightly held that it was issued. It was served on 4/3 itself. If it was, it is a disputed question of fact. If the appellant was right, the lower court should have held that it was served on 24/5 and not 4/3. But the lower court has specifically held that it is served on 4/3 and not 24/5, and hence the appeal has to be dismissed because it is not within the limitation, Your Lordship. One more thing, Your Lordship. This order is covered by the order of this Honorable High Court, Your Lordship, in CMSA 1, 3, 4, and 5 of 21, Your Lordship. Order dated 25/11/22. It is attached with my counter, Your Lordship, which says that the respondent corporation is can collect the tax of preceding 9 years. One of the contention of appellant is we have passed the limitation of 3 years, Your Lordship, but this Honorable High Court has held that we can collect the preceding tax, we can collect the taxes of preceding 9 years, Your Lordship. And hence this demand notice is valid, Your Lordship. Your Lordship may look at page number 9, Your Lordship, of my counter. Para number 11, Your Lordship. Order of this Honorable High Court, Your Lordship, dated 25/11/2022. From a close reading of the above provision, it is clear that the limitation was contemplated for the purpose of execution. 3 years' time is given for issuing a distraint order for recovery of tax due, and limitation commences from the date on which the distraint order could have been issued. 6 years in limitation and limitation commences from the date on which the right to initiate prosecution is accrued. 9 years in limitation, and the limitation commences from the date on which suit for recovery has been instituted. So, Your Lordship, by reading of this order, Your Lordship, it is clear that the respondent can collect the taxes of preceding 9 years, Your Lordship, and hence the lower court has rightly held that this appeal has to be dismissed on limitation as well as the demand notice is valid, Your Lordship.
For order 1611, both matters.
Already Prabhakar Rao, V. Durga Nageshwar Rao.
Here on behalf of the respondents 23-24, the names, even though are coming in the bottom note of the list, printed as for the respondent advocate.
23?
And 24, Bhumne Vivekananda has filed wakalat.
We should inform that Mr. Bhumne Vivekananda has filed wakalat for R23 and 24. This is to verify.
Kiran Kumar has filed wakalat for respondent number 23.
23.
I'm sorry, brother, I filed wakalat for
24 to 25, it seems Bhumne Vivekananda.
Yes, sir. 24, 25 I filed. 23 is filed.
23 ఉంది కదా.
Kirnoday Kumar.
23 by Kiran Uday Kumar.
Yes, sir.
What is
24, 25 I filed.
no representation for the appellant?
Yes, such a Savanna.
Yes. Next. There's a short question, Miller.
Just a minute.
I'm sorry.
Yes, sir. Go ahead.
Question Miller that was called for consideration of this control service. Whether Miller,
Proceedings are evidence.
it is in the expedient in the interest of justice Miller to initiate any criminal prosecution under 340. Miller, the respondent or petitioner in the IA is only bringing certain facts to the notice of this honorable court. It is not under which section we fight or Miller. What are the pleadings in the petition? They are not germane for deciding issue. Because there are three sorts of contemplates a sumoto power. But the information should be lost to kindly take for a minute to 40 minutes. Then for an application made to it on this behalf or otherwise. Otherwise means that is a sumoto power. And Miller, under the code, your lordship would find such a sumoto power. One is the revision minutes. Lorships are very well other 397 401. There is no right of revision. Only the power is conferred with this honorable court. Similarly, made 190 by taking provisions. The court you made vested with the power of sumoto. So, my friend's contention that My readings are not correct, whether it comes under 195, 1B or 1-2, they are not necessary for this matter. Only thing is, if this honorable court comes to the conclusion that this person has not come to the court with clean hands, and the person has filed a document wherein admittedly there is an interpolation. That's you have to kindly note. Admittedly there is an interpolation. It is not their case that there is no interpolation into the document, or something is added to the document showing the petitioner as an accused. They take different pleas at different stages. Before the Supreme Court, they take the plea that it is a clerical error. Here, they take different plea. Now, there is no explanation given by the respondent in the IA as to how such a correction has come here, such interpolation has come on the document. Now, difficulty is that we will not be in a position to explain the document because it's not from our custody. It has come from the custody of the election petitioner. The election petitioner has watched that this document is a genuine document. There is a verification under the RPR. Hence, the contention raised by my friend that requires certain categories of proving a document doesn't arise in this case. It is for this honorable court. Now, when they have raised the dispute with regard to whether he is accused or not, the only course left in this honorable court, with great respect, calling for the record under 91. The 91 CRP is the power of this honorable court, your worship, is very vast.
The record which was referred by the honorable.
That original record, they have to be called for from the concerned court. Then you let minors go through. If you have to come to the conclusion, such an entry of showing BP Patil as an accused.
It's still required in since they already Supreme Court
just submitting they found that it is not there in the original document. A1 original.
I have gone through.
IA1 of 21 minutes. We have obtained certificate copy subsequently, not the interpolated document. My friend has gone there, it is on record, the petitioner stated, the counsel on record has gone to the court, not that one, original IA1.
Original IA1. I'm making a note.
The certificate copy is attached. For a minute, you lost the kind of similar for my satisfaction. This is the if it is available, you lost the otherwise, not just.
That is choose it. Yes, sir.
This is the certificate copy given subsequently. Where your lordship would not find the BP Patil and others. From where they got it, the question would be it is for them to establish that yes, an interpolated document is filed by mistake. There should be some explanation.
Yeah. It is Mandigar flat. Yes.
But now, my life and contention is it is not in the body, it is on the top, it will not have any bearing on the case. But we are not on the case. But the lordships are very well aware. Each issue will have its own periphery. But I go to a civil case, after the lordship would see the issues, evidence, everything. I go to a criminal case, preponderance of property, lordship pay, full liquidity. But in the election petition, each stands on very technical grounds. Lordships are very well aware, even recrimination petition, lordship must have come across. If I don't file a recrimination petition, my votes, my invalid votes or valid votes will not be counted. But such a technical law is this. This will have a far-reaching consequences on the elected candidate once the election petition is allowed. A person declared democratically will be declared as candidate as a candidate not qualified or disqualified by this honorable court by virtue of the documents and the pleadings. Hence, when you file an election petition, they have described that verification should be there for each and every document that you rationally kindly see. You don't find this in any other law. CPC also we file the document and then we show that. But in writ petition also we say whatever the contents in the writ petition we give a certification. But in the election petition, election law, where they have to the election petitioner has to certify that all these documents are benign within his knowledge. Once he has given such an undertaking of certification minutes. Let us kindly take minutes 83. Contents of petition. Election representation people said. Section 83. Minutes. Contents of the petition. An election petition shall contain concise statement of material, shall set forth all the particulars of any corrupt acting of the petitioner, including a full statement as possible of the names of the parties, shall be signed by the petitioner and verified in the manner laid down in CPC for the verification of pleadings, provided that where the petitioner alleges any corrupt practices, the petitioner shall also be accompanied by an affidavit in the prescribed form in support of the allegations of such corrupt practice and the particulars thereof. Then any schedule or annexed to the petition shall also be signed by the petitioner and verified in the same manner as the petition. This clause, a special clause in the statute, where it contemplates that the schedule or annexure shall also be signed by the petitioner. That I do get the subject to what you are. I have not found such a provision in any other law. Lost experience. I have not found in any other statute where there is such a contemplation. This is contemplated because person should come to the court with clean hands. They should not produce any document which will
You have to answer one
Yes,
thing. The argument was, since it was not in any proceeding as referred, that is to be answered. And one more thing.
Yes.
The argument of the Alliance Senior Counsel was, since the document is not marked by the party,
both are
it need not be welcomed. So you have to answer.
33A for me to I'll go back to the issue. 33A of the Representation of People's Act. Right to information.
Yes.
A candidate shall, apart from any information which he is required to furnish under this Act or the rules made thereunder, in his nomination paper delivered under subsection 1 of section 33, also furnish the information as to whether he is accused of any offence punishable with imprisonment for 2 years or more in a pending case in which a charge has been framed by the court of competent jurisdiction. Let's kindly pause it for a minute. This is whether he should be an accused. The offence is punishable with more than 2 years, and charge should have been framed. These are the three ingredients for 1. 2 is concerned. He has been convicted of an offence other than any offence referred to subsection 1 or subsection 2 or covered in subsection 3 or section 8 and sentenced to imprisonment for 1 year or more. These are the 2 restrictions statute prescribes. One is charge should have been framed. Second one is he should have been sentenced to imprisonment for 1 year or more. Admittedly, in this case, 2 cases he was sentenced to fine. He need not disclose it. Then, so far as first case is concerned, first category is concerned, he is not an accused. That is our specific case. Now, with this background, let me kindly see. The first one, let me kindly take for a minute 195. I make a distinction here. Filing and marking. My last kindly note that filing of a document in the proceeding and marking a document. These are the 2 different situations contemplated under the statute. Filing is any document can be filed. Tomorrow, somebody can say, I'm just relying on the document. He need not mark it. Suppose he doesn't mark it, he cannot rely upon the document. In the event where the document is in the disadvantage of the plaintiff, he files a document, he doesn't mark it, then it comes to the notice of the defendant that it is the disadvantage of the plaintiff. Defendants can confront it to get it marked. So once the document comes on record, whether it is marked by the petitioner, respondent, or by the court, there are 3 minutes. One is the petitioner can mark it. Respondent can confirm the document and mark it. Third minute, honorable court minutes who want to say mark it.
That is for the purpose of appreciation. Appreciation in the original case.
It is for the purpose of appreciation so far as the minutes are concerned. When it comes to minute, a forged document is there. Assuming minute is not marked. For a minute, I argue is different. It is not marked. We have not marked, they have not marked, court has not also marked minute. Then minute, the question will be minute. By filing those documents, that document, and making the pleadings in the petition, get the verification, whether it amounts to minute, making the document part of the record. Whether the pleadings made in the petition minute would amount to misleading this honorable court, thereby minute, the jury is attracted. When division bench, my Lordship Justice Ramesh Ranganathan said, it need not be a document. Even the pleadings minute, if your pleadings are misleading, if your pleadings are to the effect that they are completely contrary to the document evidence, still minute prosecution can be launched. That is the ratio laid in the division bench. 195.1, I distinguished from the judgment are fine. 195.1, you lost look at it. We are concerned only with minute public justice in the three categories. My friend has categorized to 3 minutes. No court shall take cognizance of any offence punishable under 172 to 188 of the Indian Penal Code or any abatement attempt or any criminal conspiracy commission except on the complaint in writing the public. Then will be 1 minute of any offence punishable under any of the following sections of IPC, namely 193 to 196, both inclusive, 199, 200, 205, 211, both inclusive, and 228. When such offence is alleged to have been committed in or in relation to any proceeding in any court. My lords, kindly see minutes. Then, except on the complaint in writing of that court or by such officer of the court as the court may authorize in writing or some other court to which the court is subordinate. Now, minutes, the interpretation of 2 minutes. Sorry, B1. When such offence is alleged to have been committed in or in relation to any proceeding in the court. Now, the first question is whether filing a document before the court in any proceeding would amount to in relation to proceeding in any court. That is the question. You must kindly take for a minute the judgments filed by us. The bunch of 10/4/23.
Judgments filed by the other side.
No, we filed the document.
Along with the.
This is dated 10/4/23. It starts with Samson Arthur.
Where occurred.
Oh, sir. Last time we argued the first case is Samson Arthur, and then Vandekar. Last kindly take the first judgment and read again. But before that, you last go to second judgment at page 23. This is by His Lordship Justice Nariman minutes. Well considered judgment only on the issue whether the document after filing in the court, if it is forged, or if the document is forged before filing the court, that was the issue considered by the formal court. But they are clarified on this issue there are 23 minutes at page 45. At this stage, You also got it?
Yes. Yes.
At this stage, it is important to understand the difference between the offences mentioned in 195 1B1 and section 195 1B2 CRPC. Where the facts mentioned in the complaint attract the provisions of section 191 to 193, section 195 1B1 CRPC applies. What is important is that once the sections of IPC are attracted, the offence should be alleged to have been committed in or in relation to any proceeding in any court. Thus, what is clear is that the offence punishable under these sections does not have to be committed only in any proceeding in any court, but can also be an offence alleged to have been committed in relation to any proceeding in any court. The lordships are made in clear terms, categorically distinguished. Once the document is said to have been interpolated, forged, whatever is there, 191 to 193 attracted, it amounts but in relation to the proceedings. It did not be made before this honorable court. But 195 1A now law is settlement. Suppose A forges the document outside, produces before the court. It doesn't preclude the other party to initiate proceeding outside the court. We can file a private complaint or a police report. But if the document is corrected after filing in the court, then the bar attracts. That bar is not attracted for the second category of cases. Let's so far their interest is solved.
Yes, sir.
That's there in the same judgment. Well constructed. There are 26. Contrast with section 195B1, section 195B2 CRPC speaks of offences prescribed under 463 so and so. That such offences are alleged to have been committed in respect of a document produced or given in this proceeding. What is conspicuous by its absence of section 195B2 are the words or in relation to making it clear that if the provisions of 195B2 are attracted, then the offence alleged to have been committed must be committed in respect of a document that is custodial is not an offence that must have been occurred prior to the document being introduced in the court. Indeed, it is a distinction that is vital to understanding the sheet anchor of the appellant's case, namely this court judgment in Iqbal. 10 minutes, and Russian will kindly go to para 30 minutes. After referring to Iqbal minutes, importantly, the court then stated that section 195 is an exception to the general provisions contained in 190 thereof and creates an embargo upon the power of the court to take cognizance of certain types of offences enumerated in 195, which may necessarily follow the contained in section 340 CRPC. An important reason to be given by the court, which is that the victim of a forged document which is posted outside the court premises and before being introduced in court proceedings would render the victim of such forgery remediless. In that, it would otherwise be left only to the court mentioned in 340 CRPC. If the document is forged outside category 1, then court alone is vested with the party is given an option. But then the lordships have gone to the extent of para 40 minutes. Various particulars of fabricated documents are given as follows. So the lordships are referred to several kinds of documents which are fabricated. To the 36. There are 36 versions environment.
Yes.
But likewise, in recent judgment in Narendra Kumar Srivastava, the court was concerned with false affidavits that had been prepared or forged outside the court. That being so, the question that arose before the court was whether the magistrate was justified in taking cognizance of an offence punishable under section 193 CRPC on the basis of the private complaint. This court held it is clear from section 1B of 195 that the section deals with two separate set of offences. One, of any offence punishable under 193 to 196, 199, 200, 205 to 211, 228 IPC. when such offence is alleged to have been committed in or in relation to any proceedings in any court. Then minutes, next one we are not concerned. Then minute 14. On the reading of the above sections, it can easily be seen that the offence under section 195 1B1 and 195 1B2 are clearly distinct. The first category of offences refers to offences of false evidence or offence against the public justice, whereas the second category of offences relates to offences in which, in respect of document produced or given in evidence in proceedings in the court. Minutes, so minutes 340 for a minute of rush message for the other core minutes. Worship there is 340. Yes. Where upon application made to the clerk, otherwise, any court is of opinion. 340 minutes. Court is of opinion that it is expedient in the interest of justice that enquiry should be made into any offence referred to clause A of section 1 of section 95. We are harping on 195 1B. Where it appears to have been committed in or in relation to proceedings in the court, or as the case may be, in respect of the document produced or given an evidence in a proceeding of the court. So, 340 contemplates two situations. It's not the document should be marked. The statute distinguishes document produced and given an evidence. Once the document is produced, the penal offence is occurred. Once a forged document is produced, a document is some correct, whatever is there, you can't touch the certificate copy, you can't make any correction. My friends content showed that it might have been done by some third party. Now, last miss, you must have seen the Satyam case where I appeared for CBI. Where the company was having 2 crores in the bank account. The chartered account puts one more zero and issues the statement. Thereby, share value increases. But can the management say that we are not concerned with that? So, the persons who did this, we are not concerned. Person who filed the document, the last person who produced the document, the exact word is the person who produced the document before this honorable court, he is liable for all consequences. But the only explanation given by the friend is why they have not marked is that they were creating hurdles on the by marking this document, they are going to create hurdles. That's not a justifiable ground. Even today, as on date, there is absolutely no affidavit explaining how this correction was made. How this interpolation showing the petitioner as accused. At the time of filing, they may not be aware that 33A contemplate that their charge should be there. And 33A doesn't say merely because you are an accused, you are disqualified. You should publish only if the charge is clean. There is no material to show whether the charge sheet was filed or not, whether any proceedings were continued or charge was free. So, we have this.
The material available on record is sufficient for disposal of this I believe. Is it necessary to call for the record?
What I am saying, in the event,
there is
in the event, now it has come on record, there is an original document, interpolated document, and another certified copy which shows that those wordings are not there. Once your lordships accept this minutes, no need for calling for a record. Suppose my friend's contention is contradictory. He says that by mistake it is interpolation is there. Second contention is that he is an accused. Can such a thing he takes that he is an accused in a oral he doesn't mention anyway that he is an accused. But in your judgment of region, only one pair of lost the kindness in the para 67, where this lordship is mentioned nothing. First case.
para number, sir?
Let's para numbers. Let's kindly take para 9, 46, 67 and 68. By referring to several Supreme Court judgments, his lordships categorically held that even false pleadings, there are 64, where you lost by 5 minutes, 64, only one para I closed it here. False statements and suppression of material facts which affect the solemnity of court proceedings should not be readily condoned. It's not mere with regard to the forging of a document. It is not on the pleadings, not the learned it has given this finding. You cannot view minute such a behavior of the party minute who comes to the honorable court. Such minutes should not be condoned. Particularly in election petition, where minute is entire minute election petition stands on a technical ground, and minute you can't file an election petition carelessly, making several allegations and showing him other interesting. I read the pleadings, I don't want to repeat again. In the pleadings, he categorically mentions that he is an accused. In the minute verification minute, he certifies that the document is genuine. But how, in what manner minute these two, the verification and the pleadings minute can be eschewed minute by this honorable court at this time? When glaringly minute, the document is a forged document. But it is for the majesty of justice minute ultimately. That's the considered minute this one. If not, even at this stage, they produce some material to show minute how that interpolation has come, how the petitioner cannot be minute find fault with interpolation. But you have to condone such a. But not minute where even today minute in the affidavit file minute the recently in the counter file, but still minute they are harping upon the document. Having refused to mark the document, let's look at the counter reply of the counter affidavit file minute after 2 years. Still they are relying minute on the document. But the submission not the conduct of the petition cannot be minute.
Orders reserved. మొత్తం సర్క్యులేట్ చేయమన్నా ఆయన వేసిన ల్యాప్ పెట్టేసి ఎస్ సార్
567 are pending. 567 filed by the respondent. They are pending.
they are for summons of the witness. What pending summons is for the registry to issue summons. They were registered, ordered to be registered. Registry will take care of the
Lodge may direct registry to.
already I directed, I believe. All right, let me verify.
Okay.
Sarvabhaumarav.
May I please, Your Lordship?
Yes.
Your Lordship, I retrieve in the counsel on behalf of the appellant, Your Lordship. Your Lordship, it seems that none on the respondent side have come and record, Your Lordship. I request Your Lordship to kindly order notices to the respondents, Your Lordship. Senior will appear in this matter, Your Lordship.
Earlier there was no order for notice to the other side.
No, Your Lordship.
Admit enough. Six 12.
Deeply obliged, Your Lordship.
Item 31. M.N. Narasimha Reddy and Mahanti.
Short first.
ఇది చూడు బ్యాచ్ ఫస్ట్ రెడీ ఉంటున్నారు అందరూ
Short first.
రైట్ సార్
1 to 14 ఉన్నారండి. Item 1 to 14. Ayo, that's right.
I'm appearing virtually, Millet. I am here in
Okay.
court.
గుప్తా గారు
గుప్తా గారు ఆయన ఒకవేళ లేకపోతే నన్ను రిప్రజెంట్ చేయమన్నారండి.
రైట్ చంద్రయ్య గారు రెడీయా?
Sorry for.
No problem. వాళ్ళకి ఇబ్బంది.
I can apologize.
రెడీ?
Sorry problem.
పర్లేదు. Go ahead with your argument. All appeals are by the claimants.
Yeah, right. Insurance are there.
Insurance కూడా ఉన్నాయి.
Find the 6 appeal.
Okay. Item 6, item 8. All right.
Yeah. Item number 1. 1 of 1. Yeah. Item number 1 of 1. Item number 2. Item number 3 milliards. Item number 4, 5 and 7 are filed by the claimant seeking enhancement of compensations against the respondents. Whereas the insurance company of the auto, that is the ICICI Lombard Insurance Company, file appeal. Item number 6, 8, 9, 11, sorry,
10.
10 and 11 and 13 are five insurance company to set aside the order passed by the court below. Yeah. The item number 14,
13, 14 also by the insurance.
the appellants are not with item number 11, which is related to OP number 1957. It is not filed by the my claimants. Right? Yeah. Yeah.
Yes.
Para number 61, page number 19 of the
ఒకటే judgment. The appeals are in different OPs, right?
para number 61, page number 19 of the award, quite relevant. Where it is clearly stated,
All appeals are against the same judgment or by the by different claimants.
Last body, given by a common judgment.
common judgment separate decree. In the policy, para number 61, in the policy, it is mentioned that third party, it is not mentioned how many passengers covered under the policy. There is such mention. The package is, the policy is a package policy. Package policy. It is the freedom given by section 147 to the insurance company to cover any liability over and above the prescribed limit by the one of the vehicle or insured. Package policy. Irrespective of the carrying capacity of the vehicle, insurance can entertain for business purpose to cover any liability. The freedom is given in section 147. Once it is so, the insurer of the auto in which this is your proceeding is liable to indemnify the owner. That is the respondent number 1. Lakshman. Is a third party. Pay and recover is ordered in the common award. Once it is so, the insurer will not incur any damages. Pay and recover is ordered in the court below. Once it is so, he will not he will not incur any damages. I request Millard.
What was the capacity of the auto?
Capacity 4.
How many passengers were there?
7 were there. There were 7 persons.
No,
7 persons. Policy is not issued for coverage of 3 persons only. It is not there. It is for carry more than 3% by virtue of the package policy. Package covers the persons who are seated in the vehicle. I request me that SCC 2015 359 147 clause 1. I request the Honorable Court. Sorry. Yeah. It is also finding that apart from the persons traveling in the particular bus, persons walking on the road were involved in the accident. If that is so, tribunal justified in directing appellant insurance company to compensate all those persons who died in the accident and also those who sustained injuries.
Lady. Never Ready. Fine.
50% of 50% award by the court below was complied by insurance company. Once there is finding by the court below, when recovery is ordered, there is no damages to the insurance company. Further, Milad, the RW owner of the vehicle was also examined. Lakshman, he clearly deposed in the court below, saying that there is negligence on the part of the driver of the lorry who was proceeding against him from Warangal side. For which this also covered 3 and 4 are the owner and insurer of the lorry which was proceeding against the auto. If a liability that is there that can be fixed by the Honorable Court in the court below was to be done against the respondent number 3 and 4 also. We are third parties. I request me that we are third parties. We are not driving the vehicle, auto. Any liability there, that will be shared among between the 1 and 2 and 3 and 4. This is death case, third parties. Therefore, the appeal filed by insurance company may be company, that is item number 6, 8, 9, 10, 11 and 13, to which I am related, may be dismissed and may be allowed. Or at least the order of the lower court may be confirmed.
Yes. What for your appeals?
My appeal, Milad.
For enhanced.
Item number 1 of 1, Milad.
What is the relief that was claimed in the your appeals?
Seeking enhancement of compensation.
What are the grounds for enhancement?
Yes, Milad.
What are the grounds? Enhancement given. All right. What is
Future prospect is not awarded in the court below.
I'll go through the grounds. Yes.
But as far as
Enhancement of the compensation. Future cost of was considered by the only regarding interest 9% for good. 7.5.
For future prospects are added, even if it is decreased, no. For the, all right. What are the grounds in the other appeals filed by you?
All the same issues involved. Because the already one last case you are on, and that in the case you are on, consider the future prospect. At the time of passing, the lower court has apportioned the liability, but my friend has permitted this. That is the recent case law. I am not going to discuss any because the accident is occurred between.
So it seems the appellate tribunal exonerated the other insurance company of the Auto, right?
Not the insurance company of the auto Millard, the lorry Millard against which the auto dashed.
Okay.
That they both are head-on.
Liability was fixed on the insurance company of the auto.
Auto. Millard, even according to their case, Millard, they have never alleged any negligence on the part of the
Right.
lorry to claim third party claim against that lorry.
In some of the appeals, you are for the respondent. In some of the appeals, Gupta is counsel.
And for the insurance company that has been exonerated, Millard, that is New India.
You are supporting to that extent.
To that extent, Millard, my learned friend was arguing that the third party liability also it can be affixed against the lorry. Millard, there was no claim of third party against the lorry because there was no allegation. It is filed under 166, Millard. So they have to allege any fault on the part of the lorry driver. That is not there at all. No doubt, Millard, lorry insurance covers the third party liability. But as long as there was any allegation and it was proved that the third party lorry driver was negligent, and if they proved that, Millard, the third party liability would be coming into force. Now, Millard, there is no claim at all stating that there was negligence on the part of the lorry. Even according to their own pleadings and evidence, it is the auto driver in which they were traveling, the auto driver has been negligent. There was no claim against the insurance company with regard to negligence. That is why, Millard, the Honorable Tribunal has correctly exonerated the insurance company.
All appeals are reserved for treatment. And both parties.
Applied.
Next.
For hearing item 32.
అన్నీ ఒకసారి చెక్ చేసి కరెక్ట్గా ఉన్నాయో చూసుకొని మండే నేను ట్యూస్డే ఉండట్లేదు ట్యూస్డే పంపించండి ఒకసారి చెక్ చేయండి ఎస్ ఐటమ్ నెంబర్ ఎంత
32.
File the petition for 41-27 specific additional document. Started meeting my file to work. The court is the property.
Included petition that was dismissed.
Included has been dismissed. We filed earlier itself. We filed the petition under order 41-27 for additional documents. Additional documents, and that's why that was in 2018. That's point in time that was to be taken up with the main appeal itself. I'm ready with the main appeal, but now that copy is missing in my file, unfortunately. So I need to take it.
When you will get ready, ma?
Tuesday.
Next Tuesday.
Tuesday.
No, not next Tuesday. I think I'm on leave. Next 21. Our final hearing. 21/11.
PSP Suresh Kumar and P. Banu Prakash.
As it is a case of Hindu.
ఇంటికి పట్టుకెళ్ళాలి ఎస్ సార్ ఇంజరీస్
Yes, sir. Tribunal awarded 6,31,000. The fixed loss. Tribunal has awarded loss of income is 80,000. Medical expenses 5,93,441. Transportation 5,000. Viewers in 15,000. Total comes to an amount of 6,31,000. The interest rate of 7.5% per annum.
the only grievance is there no compensation for disability.
permanent disability.
Let him complete. What is the proof that you to show that there is a disability? Very-
Kindly internal check PW 2 and 4 are the doctor.
Hmm.
Page number 2. Number 2. PW1 in his evidence report that prior to the accident he was here and healthy and was tutoring up to 10th class student and used to earn 2,000 per month and contributing the same to his family. Due to the accident, he received grievous injuries, blunt injury, abdomen, deep flowing injury to left bone and scrotum, grievous deep flowing injury over the pelvic femoral aspect of right left side extending to lateral aspect of left thigh, exposed muscle press out abdominal wall, purple cerebral pulse left lower limb, and other multiple injuries all over the body. As such, he became permanently disabled and he spent over ₹8 lakhs for surgeries, medicines, treatment, nourishment, and transport, etc. And he also spent more amount for the purpose of further treatment, surgeries, medicine, nourishment, and transport. And he has been leading miserable life of an unemployed. Apart from his marriage prospect, he also affected and he got lots of 2 academic years for prosecuting further studies. PW2 is the doctor, my lord. And the exhibit A9 to A1 to A9 are the bills that are given by the Sunrise Hospital near Nagar.
They were considered by the court below.
That has not been concerned.
Medical bills considered.
Medical means concerned. The only thing is the permanent disability that has.
What is the evidence?
PW2 is the doctor who treated the disease malady in the Sunrise Hospital that has not been considered.
What is the evidence? W2 deposed about the treatment, not with regard to the disability. Where is the evidence about the disability? Copy of his deposition, W2. No medical certificate about the alleged disability.
There is no medical.
Mari, inkem. How can you claim that there is some medical disability and some compensation need to be paid? Is it the evidence of W2 that the petitioner suffered disability?
PW2 in his examination stated that he has sustained permanent disability.
Where is the evidence? As per the award, there is no such mention.
As a tribunal has not considered, there is no certificate from the.
That's why I'm asking you how deposition of W2. You did not mark the disability certificate. Mari, income use, sir. How can you claim that there is some disability? And what is the percentage of the disability?
50%.
What is, where is the proof? You can claim 100%. Without proof, how can you?
It has not marked.
Mari, income use, sir. Income use game on that. What is it?
Medical expenses are all given.
Sensitive parts of the male involved in the accident. That is the evidence. But there is no certificate that he suffered some disability. I heard both parties. Reserved for treatment. Next.
34 and 35. Here is the rate number. Is how much you are off?
One by insurance company and the other by claim. Death case, right? Case of death.
That's right.
Death case. Calculation.
What was the
Claimed amount is 10 lakhs.
Mhm.
Awarded amount is 8,89,000.
The location of the deceased is agriculturist. Agriculturist. And the money for 6 months. Consider the local income as 7,000. The objection of the insurance company is that the land is with the claimant, and only supervisory loss is there. Seems like that the most of that the accident occurred between two-wheeler motorcycle and lorry. The deceased is not holding the driving license, but accordingly, the claim petition is not maintainable under 1666 of the Motor Vehicles Act and hard liability. But admittedly, they have not paid the driving license of the motorcycle. The other heads reasonably considered by the driver.
so ground for this dismissal is the lack of license?
Yes.
You filed your appeal seeking dismissal and
The negligence on the part of the deceased without holding driving license, already you were driving the vehicle. But it was cross-examined before the tribunal also.
is it a ground for dismissal of a claim? And can on that ground a claim be dismissed? Yes. Admittedly, the deceased is an agriculturist. You cannot claim more amount since the land is still with your with the claimants. Honest can prove that the ownership of the property, which is now with the claimants, who can as well proceed with the agriculture and earn the same amount. Had both parties. Judgment reserved.
Item 36 and 37, CSP Suresh Kumar and A. Malik.
Yes.
This two may be passed on.
Also, what about the remaining two?
Maya paying that is the insurance company.
Also, what about 38, 39?
And the other two matters, the first two matters, that is item 36 and 37 connected below. The other two matters, 38 and 39, that is two are arising out of same action, that is different, not related to 36 and 37.
Same council కదా అడుగుతుంది రెడీయా
Pass on.
4 all the 4
38 and 39. 38.
36 37
36. 36. Right. Pass on.
అదే నేను అడిగాను all పాస్వర్డ్
Final hearing item 41, Nageshwara Repagula and Tata Lakshmi Prasad.
Today also there is no representation. 41 is due. To that extent, you have no objection.
No, my lord. Even as per the income, the court has already granted 10,000 rupees considering the avocation of the claimant, my lord. That also we have no objection because only 10,000 is to be granted for 1 month as he was in hospital for a period of 1 month only.
Had counsel for respondents. 29 for judgment.
Regarding this.
Good. Adi recursive. Yes, 29 for pronouncement of judgment.
Obliged, lordship.
పెట్టుకుని నేను డెలివరీగా ఇస్తున్నాను 3 రోజుల హాలిడేస్ వస్తుంది ముందు కొంచెం అడ్వాన్స్గా సర్క్యులేట్ చేయండి.
Item 42, and was there already?
Yes. And after the 612.
Item 43, Mr. J. Prabhakar and G. Ravichandra Shekhar.
Yeah, very good.
నిన్న మ్యాటర్స్ ఈ రోజు రాలేదమ్మా బ్యాచ్ ఉన్నాయి. It's 43.
Actually, we are preparing booklets, Lordship. Actually, post.
Please for respondent.
G. Ravichandra Shekhar.
Take your question.
Yes, next.
Item 44, Srinivas Rao Madhiraja and Srikanth Harihari.
Item one of the scheduled property was granted. In respect of items 283, need to be referred to the prior court. The appellate court ruled the decree issued in that. But the main submission was, which was made not at the time of the submission, 2 months back. Was that not the another appellate judge did not consider the evidence on record. It's proper perspective. But he has ignored the vital evidence, which was there on record. But the plaintiff claimed intention based on a sketch which was filed by him in the court, which was also in pari material with a rough sketch road which was there in the earlier suit between D1 and D6. But the claim of the plaintiff was that the rough sketch which was there not as part of not earlier suit, or which was there in the earlier suit becomes a part of the record of the earlier suit, which was admitted, it becomes an official document, court document. Therefore, that should be taken into consideration for the purpose of granting the refusal. That is the main case. May I just take your answers to the order of the appellate court first and say how it is wrong. But at paragraph 26 and 27 of the appellate court judgment, or if the verses are kind of only permission to read from paragraph 20. Can I read?
Yes.
Plaintiffs have examined himself as a PW, examined grandson of late Colonel Venkaya, the son of the other branch, the plaintiff and defendant. She supports the allocation of properties as claimed by the plaintiff. Apart from the oral evidence, the plaintiff has strongly relied upon the boundaries given the final decree relating to the suitability properties therein. The defendants are also not seriously disputing their position within the boundaries given in final decree proceedings under the exhibit B1. A reading of the evidence and the findings of the trial judge will show that undue emphasis was given upon Advocate Commissioner's report, who objected partition of properties relating to survey number 384 within the suit boundaries given therein. There are other properties in the suit which are unconnected to the present litigation. The relevancy is survey number 384. Both parties to the present suit admits with regard to the boundaries of the land allocated to late Achaya in the oral partition between him and his brothers within the boundaries given in forest number 24 of 73 on the file of the support common. The said suit was filed by the defendant number 6 against defendant number 1. Though the preliminary decree was ex parte, the final decree was taken basing on the preliminary decree. The defendants admit the possession of properties in terms of the decree within the boundaries given there. Therefore, the boundaries of the property allocated to father of the defendant 1 and 6 will throw some light in assessing the plea set up by the plaintiff and the defendant are correct or not. The boundaries referred in final decree proceedings with reference to the suit schedule property. Kindly just I'll take your losses to if necessary to this. The plaintiff filed pictorial representation. Can I read? The plaintiff filed pictorial representation of properties divided among the sons of late Akshaya and the exhibit A4. The said pictorial representation reads as follows. Well, this appears to have been marked as exhibit B5. Then, the defendants have also filed pictorial representation of the divided land. This is marked by, given by the defendants. The defendants have vehemently opposed the admissibility of exhibit A5, the pictorial representation filed by the plaintiff with regard to the allotted land in the oral partition. No doubt, exhibit A5 is a diagram prepared by the plaintiff. But it's not an official document, it is a diagram prepared by the plaintiff. That itself is not a document of partition showing the allotted shares, and the same cannot be relied upon to hold the who are in possession of the lands depicted therein. The defendants as well as the trial judge has failed to take note of the thing that exhibit A5 is not the document showing the allocated shares, but it is a diagrammatic representation of property on the strength of the boundaries given in the partition suit between defendants 6 and 1. The trial judge in his findings has categorically given the finding that exhibit A5 is in tune with, this is wrong, this is the wrong finding, it's not so stated in the trial court judgment. I'll take your question. He is in tune with the boundaries given in the schedule relating to survey number 384 in the final decree. Therefore, exhibit A5 can be only taken into consideration to easily understand the lands which are allocated to defendants and other shareholders in fixing the respective shares on the strength of the boundaries mentioned in the final decree. In the diagram filed by the defendants, he has not given full details of other shareholders' land except one portion of the land allocated to each of the shareholders and his own land. A comparison of the diagram prepared by the defendants and the plaintiffs, the item 4 referred to in the diagram exhibit A5 claimed to be in possession of the defendants, and the share of acre 1 is also shown in item number 5 of exhibit A5 on the western side. Therefore, it is necessary to examine the claim of the defendants vis-a-vis the boundaries given in exhibit A4 or exhibit B1. If the defendant's contention is that item 4 of exhibit A5 belongs to them, the south side boundaries must be the land of Appaya plaintiffs, item number 3.2, relating to item number 4 of exhibit A5. In the boundaries, it is given land of Swarna Venkaya and not Appaya. This goes to show that serial number 4, which the defendant claims to belong to them, is apparently incorrect. In so far as item number 3 of defendants in exhibit A4, exhibit B1, the north side boundary shows Tikati Cheru. If this boundary is compared with sketch filed by the defendants, it shows that acre 1, the north side boundary must be B2, land of Swarna Venkaya, Janaki Ramaya, Raghavaya, and Ananta Ramaya plaintiff. The north side boundary of the final decree relating to item 3 is compared with sketch under exhibit A5. The same is in tune with the sketch prepared by the plaintiff. These aspects of boundaries were not rightly considered by the trial. This is how not to analyze in dismissing the request of the plaintiff in respect of items 2 and 3 of the suit schedule act. Sketch of the plaintiff in exhibit A5 clearly in tune with the boundaries in exhibit A4, which is also wrong conclusion, but final degree, and the evidence is not exhibit A5, but the boundaries in exhibit B1, exhibit A4, which are not disputed by the defendant. Therefore, the trial judge misled in appreciating the evidence and finally came to the conclusion that the boundaries of the plaintiff is not tallying with the boundaries in exhibit A4 but exhibit B1. Accordingly, the findings are liable to be set aside. In the result, appeal is allowed. Now,
kindly now take to the trial court's judgment. The relevant portions will not start according to the paragraph 16 onwards. At page 36.
Yes.
I may just clear itself submit. This exhibit A5. The entire contention of the plaintiff. That exhibit A5 is part of final decree proceedings.
But A5 is rough sketch.
Rough sketch. He says that it attained an official status by becoming part of the earlier final decree proceedings in another suit between D1 and D6. This is his contention. But what happened is when that was being shown as that an application was filed before the trial court, saying that it is likely to cause inconvenience to us representative. We do not know how did this sketch come into the proceedings. Therefore, it requires to be deleted. But that IA has been allowed. Can I just take your losses to note allowed? And that has been discussed and said that you can't rely upon. Trial court says that you can't rely upon exhibit A5. If exhibit A5 is not relied upon, the plaintiff did not establish his case about the location of his land and interference by the defendant. If that finding is not based on any evidence at all, that is likely to be the contention cannot be accepted and injunction cannot be granted in the submission that the defendants make in the trial court, which is accepted. Same contention was raised before the appellate court, but appellate court feels that not exhibit A5 as it is a part of earlier suit proceedings in the final decree proceedings, it has got a legal sign. This is the that if your lordships are kind enough, kindly pay to this paper which you have just now given to your lordships.
What was the IA? IA1.
No, I'll just say IA number.
IA was allowed by the trial court.
IA was allowed by the trial court. IA number 672 of 99. It was allowed on 22/8/99. Look at the last 2 pages of the green paper which I have just now. This is a fiction 500 law. To remove the rough sketch, rough sketch, which was attached to the final decree by oversight and which was not prepared by the commissioner. It is averred in the affidavit filed in support of the petition that respondent plaintiff herein filed suit in case number 24 of 73 and the preliminary decree was passed on 30th of August 75. Thereafter, the commissioner was appointed for effective partition of the scheduled property, and on his filing the report, the court passed the final decree on 22/7/1990. While passing the final decree, some mistakes crept in. As per the commissioner's report, the maps were prepared by the commissioner with the help of the surveyor. One, Swarna Anantaramaya filed objection before the commissioner along with the map. Swarna Anantaramaya is the plaintiff in the present suit. That map was not prepared by the commissioner, but while passing a final decree, map filed by Swarna Anantaramaya was also enclosed to the final decree. In fact, it was not prepared by the commissioner. The petitioner, being illiterate, could not know about the aforesaid mistake being crept in while passing the final decree. Therefore, he prayed to remove the map which was prepared by Swarna Anantaramaya and which was wrongly enclosed to the final decree relating to so and so. The respondent appeared through his advocate so and so. I have gone through the report of the commissioner and the rough sketch file relating to the plain scheduled property. The commissioner has divided the entire plain scheduled property by giving marks A, B, but one of this sketch, which is relating to survey number 384, does not contain these villages of the commissioner or survey. It also does not bear the names of
the petitioner and respondent. So the rough sketch plan in survey number 384, which contains the names of S. Venkaya, Achaya, Appaya, does not relate to the suit scheduled property and it is wrongly enclosed to the final decree. Therefore, I direct the above plan to be removed from one of the enclosures of the final decree. This is how broad the but this was marked, this rough sketch was again prepared by the plaintiff and it was filed into the courts and it marked as exhibit A5. The entire reliance melody is on the exhibit A5, which is nowhere now after this order. That map melody loses its significance is the submission that I make. Now, Lord, kindly come to.
That order in a year 672 is final. That is not challenged.
It was not challenged. But paragraph 16 onwards, right? If the nurses are kind enough. Of the trial court.
Yes.
But just above paragraph 16, 10 lines maybe. In other words, from there can I read? In other words, his contention is that while 1 acre of land of the defendants is situated on northwest corner, 1 acre and 18 foot of land of plaintiff third item is situated on northeast corner of the defendant's land, acre 4. But the defendants, as already stated, disputed the existence of item 3 of the suit schedule. Thus, the fact remains that the boundaries of items 2 and 3 of the plain schedule are in dispute, and plaintiff is not able to establish by way of oral evidence the existence of the boundaries to these 2 items, as has been mentioned by him in Exhibit A5. This is for the contention. The learned counsel for the plaintiff, however, tried to place strong reliance on Exhibit A4 final decree and the boundaries mentioned therein. And on the strength of Exhibit A4 final decree, the plaintiff's counsel contended that pursuant to the final decree, the boundaries of land in an extent of 8 and 19 guntas belonging to the defendants 1 to 5 and in one set and defendant number 6 in another set have been clearly demarcated by fixing the boundaries to their respective care. His contention is that the final decree proceedings instituted in this earlier suit filed by defendant number 6 against defendant number 1, a commissioner was appointed to demarcate the boundaries of the defendant's land, and at the time of survey conducted by the commissioner, the land of defendants as well as the land of the plaintiff in survey number 384 was surveyed and boundaries have been clearly demarcated. He therefore contended that pursuant to the said survey conducted by the advocate commissioner in the final decree proceedings, the defendants are in possession of their respective shares which were demarcated and the plaintiff is in possession of items 1 to 3 as has been demarcated by the surveyor at that time. Thus, according to the learned counsel for the plaintiff, the boundaries of all lands of the defendants as well as the plaintiffs have already been fixed by the surveyor in the final decree proceedings, and even though the plaintiff is not a party to the suit, himself and defendant number 1 to defendant number 6 are in peaceful possession and enjoyment of the respective bits of land as has been demarcated by the advocate commissioner. The defendants are now stopped from disputing the boundaries fixed by the advocate commissioner. Murad, he feels that Murad Exhibit A5 is the one fixed by the advocate commissioner. This is the Murad, the wrong impression in which the plaintiff reads, which is appended to the final decree and strongly contended that the existence of boundaries of the two properties herein as shown by him Exhibit A5 cannot now be disputed by the defendants since the defendants did not question the final decree or the map attached. This is the mistake what he is dealing under. This was disputed and IA was filed, IA was ordered, that sketch is removed. This is what I am trying to say. Then kindly go to paragraph 19. On the basis of the above final decree, can I read?
Yes.
On the basis of the above final decree, especially the sketch map appended to the same, which is enclosed as last sheet in the final decree, the plaintiff tries to contend that he is in possession of item 123 as shown in the said sketch map, and the said final decree having attained finality, the defendant cannot now dispute the correctness or otherwise of the boundaries shown in the sketch map appended to the final decree. He further contended that while drawing my attention to the cross-examination of DW1, that DW1 having admitted the boundaries to items 3, 1 and 2 of the suit schedule attached to the final decree in the earlier suit, the defendants cannot now retract from the said position and dispute the boundaries of the plaintiff's land. At the cost of repetition, it must be stated here that thrust of the argument advanced by the plaintiff is that the boundaries of defendants 1 to 6 and himself have already been determined by the Advocate Commissioner in the earlier suit, and those boundaries having received a seal of acceptance from the competent court of law in the earlier suit, and the defendants having admitted the boundaries fixed by the Commissioner to their lands, cannot now dispute the boundaries of the plaintiff's land, so and so, which are quite adjacent to the lands of the defendant, so and so, are the two items of properties belonging to the defendant situated in survey number 1, which were subject to partition in the earlier suit. According to the plaintiffs, it is very same items which fell to the share of the father of the defendants in partition that took place about 65 years ago, and that even according to the defendants, northern and southern boundaries therein are the lands of the plaintiffs, and that therefore it must be safely presumed that the defendants have admitted the existence of items 1 and 2 of the suit schedule herein within the boundaries mentioned by the plaintiffs in the suit schedule. It is no doubt true that final decree, the scheduled properties concerned in the earlier suit was shown, and the item number 3 therein relates to the lands of the defendants in survey number 384. It is also true that the northern boundary of so and so, so and so. Kindly omit that. It is also true that the boundary mentioned, these portions also kindly omit. Kindly go to mirror. Next page. Since admittedly from the in the middle. In fact, those boundaries of the land in survey number 384 shown in the suit schedule, which is concerned in the earlier suit, are not in existence today. Since admittedly the entire land in the survey number 384 was surveyed by the Advocate Commissioner subsequently in the final decree proceedings, and has been admitted by DW1 in the cross-examination that he only know the boundaries of the lands between his father and his senior paternal uncle. The true question, therefore, is that the boundaries which were fixed by the Advocate Commissioner in the earlier suit to the land of the defendants in survey number attained finality, and the plaintiff having never raised any objection to the fixation of the boundaries to the said land of the defendants, and also to the neighboring land belonging to the plaintiff in that survey number, he cannot raise any dispute afterwards about the correctness of those boundaries. Above all, the very basis of the plaintiff for drawing exhibit A5 rough sketch is the alleged sketch plan appended to the final decree in the earlier suit. As already stated, it is the said sketch map which has been strongly relied upon by the plaintiff to prove the boundaries of items 1 to 3 of the suit properties. But the defendant's counsel contended that the said sketch map which was appended to the final decree does not reflect the true picture, and the boundaries shown in the said sketch map are not in accordance with the boundaries fixed by the Advocate Commissioner to their land in the final decree proceedings, and that the said sketch map was somehow come to be attached to the final decree by some mischievous act. He therefore filed interlocutory application number 672 of 99 in OS number 24 of 73 under section 2 and 2, to delete the said. He contended that the said sketch map was not prepared by the Commissioner. As could be seen, Exhibit B9, certified copy of the order dated 22/8/99 passed in that interlocutory application. The submission was allowed by the Honorable Civil Judge. As a consequence, the so-called sketch map, which was appended to the final decree, remained deleted from the final decree, and therefore it must be deemed that it has no authentication at all. But the learned counsel for the plaintiff, however, contended that there is no endorsement on the sketch map by the Honorable Senior Civil Judge to the effect that pursuant to the orders passed by the interlocutory application, sketch map stand deleted. This is the contention, but he just says that though the order in substance was passed, practically it was not on the map, it was not written saying that it is deleted. Therefore, it still continues to be the part of the record is the contention, not the plaintiff asserts. But I am not able to agree with the said contention, since the same is not at all tenable. When once an order is passed by the competent court of law deleting the said sketch map, whether or not an endorsement is made on to that effect, it must be deemed that the said sketch map remained deleted from the final decree from that date onward, and the said order is therefore binding on the parties. Plaintiff, who is not a party to the earlier suit, cannot be permitted now to place reliance upon the sketch map, which was by mistake appended to the final decree but ultimately ordered to be deleted. The plaintiff cannot derive any benefit of the said mistake. As a matter of fact, as could be seen from the said sketch map appended to the final decree, it does not contain even the initials of the surveyor or the advocate commissioner. Therefore, having due regard to the order passed by the Honorable Senior Civil Judge deleting the sketch map, I have no hesitation to hold that the so-called sketch map attached to the final decree has no sanctity nor any authenticity at all, and the contention built up by the plaintiff on the basis of such deleted sketch map by pressing into service a similar map as in this may be read as exhibit A5. If it is wrongly typed as A4, is liable to be rejected as being without any basis. Above all, the burden of proving his contention that he is in possession of items 1, 2, 3 or the suit schedule within the boundary shown by him in the plaintiff is very heavily on the plaintiff. In order to discharge that burden, plaintiff has to adduce cogent evidence by examining the neighboring rights, by producing the documents of the landowners who are neighbors of so and so. These documents would certainly support the case of the plaintiff. Instead of adducing the evidence of independent witnesses like so and so, plaintiff chose to place heavy reliance on the final decree proceedings in a suit which was litigated between his opponents, defendants 1 and 6, and also the oral testimony of PW2, who is admittedly inimically disposed towards the defendant, even though PW2 was fully supported the case of the PW1 in respect of the boundaries of items 2 and 3. In the absence of an independent evidence and any document in respect of the interesting testimony of PW2 cannot be given much weight. It is also pertinent to mention here that the earlier suit is mainly concerned with the respective shares of defendants 1 and 6 and the boundaries thereof. Final decree was passed determining the shares of only parties to that suit. The properties which are subject matter of this suit were not made subject matter of the earlier suit. In the absence of fixation of boundaries to the suit properties herein by the advocate commissioner in the earlier suit, plaintiff cannot try to place any reliance upon the boundaries of the land of the defendant as fixed by the advocate commissioner appended in the earlier final decree proceeding. For the above reason, this is how. But this has not been appreciated, and in fact, the Learned Appellate Court did not even look into that the document which was filed before the court below, which was marked as Exhibit B9. Will your lordships kindly go to the appendix of evidence? Kindly forgive me and just have a look at it. Appendix of evidence. At page 44, Exhibit B9.
Yes.
Is the certified copy of the order passed in the IA. Once that has come on record, my lord, and as there is no other evidence, my lord, supporting the case of the plaintiff, and as the Learned Appellate Judge did not, my lord, go into this, the effect of the order passed in Exhibit A9, the judgment of the Learned Appellate Judge, my lord, with great respect to the Learned Judge, my lord, it is liable to be satisfied. But your lordships are aware of the parameters of deciding a first appeal. Probably your lordships, I just pass on to you judgment.
Yes.
I have noted.
Yes, what do you think?
One benefit passed.
Yes. Okay, I'll go through those judgments. So there is no dispute about that particular finding.
A final order. Though in minute there is no finding by that earlier suit in 24/73, one of the independent assessment, because notwithstanding with regard to whether it is attached or not attached, but I have to consider before your lordship that it is not part of that previous suit. To show the exact distinct and identifiable boundaries, the plaintiff filed that was sketched before that court. and independently, my lord, to show the exact possession of the property of the plaintiff and the distinct and identifiable property of the defendants, because D1 and D6 are none other than the cousin brothers of the plaintiff only. Because entire this 384 is consisting of 25 acres. It was divided equally amongst the father of the D1 and D6 and the plaintiff. In 3 equal shares, my lord, it was divided. 8 acres, 19 guntas equally. Insofar as, my lord, the property to an extent of, my lord, 8 acres, 19 guntas, which fell to their share from their father. But, along with the other properties, since, my lord, they were not unable to, my lord, partition the property, the previous suit was filed between D1 and D6 in respect of 18 acres, 8 acres, 19 guntas. And, my lord, since they were, my lord, trying to interfere and with the property, at that point in time, the plaintiff filed this rough sketch before the court below to show the distinct and identifiable boundaries in respect of his property also, because he is also from his father, he is holding 8 acres 19 guntas, as it is consisting of 25 acres. To show that whatever the property that fell to share of his father, around 8 acres 19 guntas, and subsequent to the demise of the plaintiff's father, since the property was also devolved upon him, he obtained an independent Pattadar passbook and title deeds. They are already marked before the Islamic court. And to show the such kind of a possession over the property in question, he filed the rough sketch map in the before the advocate commissioner. Ultimately, my lord, there is also no finding by in the earlier final decree proceedings that this is, my lord, not at all tenable in law. Since it was only a wrongly, my lord, attached to the decree, but the court below came to conclusion since it was not prepared by the commissioner, therefore it may have to be deleted. That's all, only to that extent. That itself, my lord, will not invalidate the rough sketch, which has been independently filed by the, my lord, by the plaintiff in the present suit. If there had already been a finding saying that this rough sketch is not in consonance with the boundaries that is already in existence in respect of 24/73 in the earlier suit, where the issue would have been different. Simply, my lord, the earlier round of litigation in the partition suit, since the court came to conclusion saying that this rough sketch was wrongly attached, since it was not prepared by the commission, therefore it may have to be deleted. So therefore, my lord, my response submission that it will not invalidate, and the learned appellate court independently assessed the exhibit A5 again, rehorsed the, my lord, other issues that are there before the court below, independently assessed the evidence of exhibit A5 with reference to the decree that was already obtained between D1 and D6. So, being a final court of fact, the lower appellate court may not properly appreciated the entire evidence on record. The Lordship knows that in an injunction suit, that they have already established that I am in possession of the property by exhibit A1 to A5. Lordship may kindly see the exhibits filed by me. The revenue records have a title deed exhibit A1 is there. Lordship will get that in material paper filed by page 44. These are the exhibits marked. Title deed exhibit A1, Pattadar passbooks, fiscal receipts also for 97-98, and the final decree and the rough sketch. These would demonstrate that he has been exercising possession in respect of the suitable property to an extent of 8 acres 19 guntas. And under the guise of this decree that was passed in their favor in 1991, the final decree was passed in 1991. And there was an interference on that ground, my lord. He filed a suit in 1999. Independently, my lord, establishing before the trial court, saying that he has been exercising possession of the property. And the other person, my lord, PW2 was also examined to show that, my lord, the plaintiff has been exercising possession of the property. The substantial question of law, the particular is represented by counsel for the appellant. They are not, in fact, they are all the factual controversies. I kindly see that page 4 after the grounds. But it is already settled because there is no debatable question of law that will interfere under section 100 of CPC. The facts and circumstances entered for injection is legally sustainable in of the fact. A single document of title and possession. You have to know that under section 6 of the ROR Act, there is a presumption. Exhibit A1 and A2 demonstrate that Millard he has obtained a Pattada passbook and title deeds. Unless the Millard contrary is proved, the entries in the revenue records Millard may have to be presumed to be true and correct. There is a presumptive value attached under the ROR Act. And the 636 are also there. So Millard is that the revenue proceedings Millard this title deed is there. And that the question of law is no more receptive. It has already been decided by various courts from time to time. Next one, my lord, without verifying the evidence of the plaintiff, contrary to the plaintiff in a superintention stand or fall on his own strength, but not on the weakness of. But independently, I have assessed my evidence. Firstly, my lord, there is also an admission in the written statement admitting my ownership. The possession also, my lord, will follow slightly. Weakness, I have completely not relied upon their weakness, but I have only just brought it to the notice of the court below, saying that I have been independently exercising my right by virtue of the revenue entries.
What was the admission? Admission with regard to title.
Yes, my title will not have admitted. The trial court also will not.
Let him complete.
Kindly similar page 26, number 3. Defendants 126 filed a written statement admitting that the plaintiff is the owner and possessor. Dry land to an extent. The defendants expressed ignorance as to whether the set survey number was subdivided and renumbered as 382/C. The defendants also admitted that the plaintiff inherited the agricultural land from his father, Swarna Appaya. The defendants admitted that the plaintiff's father has got two natural brothers, Swarna Venkaya and Swarna Achaya, and there was a partition between three brothers. The defendants further admitted that in the said partition, the three brothers were enjoying the lands which fell to their respective shares. It is also admitted that after the death of plaintiff's father in the year 1993, the plaintiff came into possession of the suit property. 58 comes into play. Then the defendants further admitted that the defendant number 196 partitioned their properties in this suit right 24/73 on the file of senior civil judge, and a final decree was also passed demarcating their respective shares. The defendants, however, denied the allegation that the plaintiff had converted 4 acres of land into irrigable land and has been raising paddy crop, and he kept the remaining land for grazing purpose. They also denied the allegation that they had tried to interfere with the plaintiff. Out of 8 acres, what I have pleaded is that 4 acres have cultivated the land, and 3 acres remaining land, it is in grazing purpose, for which they are denying. But insofar as the ownership and possession respect to property, as to how I derived the entire property from my father, also there is an admission. 58 of Indian Evidence Circular admitted fact need not be through as watching. That is aware. So, in the light of this, apart from this decree, whatever the boundaries that are there in the 24/73, an independent assessment has also been given by the learned appellate court, being the second court of fact. And there are since then no substantial question of law, which is in fact duly debatable before this honorable court is brought before your lordships, for a consideration. It trains to be in consonance with 100 of CPC. all other matters substantive question of law only in regard to questions of fact. And if any matter the others, the question of law which they have framed have already been settled by the Supreme Court and this Honorable Court from time to time. The weakness of the defendants. All my response.
You're saying something.
That 25 acres and 17 gunters of land belongs to the family. But the family tree was extracted.
Of course, in the written statement, they have admitted the portion title.
No, I mistake. You are also sorry. Please also kindly go to page 10.
Yes.
Not apparent before your lordships are at the bottom. But Manikyam is given to your lordship. Then Lord Varna Lachaya was the original ancestor. Then Appaya son is the plaintiff. And they're all one family members. Each one got out of 25 acres and 17 got around 8 acres, 8 and 18 gunters. Then got in the partition way back in 1965 or so. Each one got 8 acres and 18 gunters. That far it was admitted. That far it was admitted, saying that, and the issuance of Patidar passbook, he was given Patidar passbooks, I was given Patidar passbooks. I was paying tax, kindly take to Lord's Exhibit B4. Certified copies of the Pahanis I filed. Of course, I did not file Patidar passbooks. I have filed Pahanis to show that not I am in possession of the property. We want to be poor. What I was trying to say is not about the extent of owning by each one of the family members, that is 8 acres, 18 gunters, was admitted. Not my humble submission, that stay sentence which is said that what was admitted is he is in possession of that extent of 8 acres and 18 gunters which was allotted to him. Maybe it was wrongly recorded as suit property. In the judgment.
Heard both parties. Judgment is out.
Item 45, G. Venkat Reddy and J. Shivakumar, J. Venkatesh Gupta.
It is MUOP and the main petition is MUOP and now respondent. It is coming for argument, right? Time for it is.
You are for respondent.
I will respond.
None appeared for the appellant.
Because I am suffering with
612.
Indeed.
612.
Item 46, item 47, Devatpal Reddy, Kas Reddy and A. Ramakrishna Reddy.
Restrict your inform to the reverse session.
The question of appellant. 1511.
Item 48, Somanchi Venkateswarlu and T. Srijan Kumar Reddy.
Hardship and representing so much and it was actually from the others.
The question of appellant. 1511.
Item 49 to 52, J. Sandhya Rani and A. Ramakrishna Reddy.
Right, sir. 41. No representation for the appellant. 2211 under the caption for dismissal.
Item 53, K. Rai Babu and S. Surendra Reddy.
Council Ravi Babu na Marner.
Yes, Srinivas Reddy.
Two. Tia.
Srinivas.
Srinivas. Registry director to print the name of A. Srinivas Reddy as counsel of appellant. List on 22/11.
Item 54, Ajay Shravan Kumar and M. Sritman Reddy.
No representation for the appellant. 22/11 and
Item 55, Ramchandra Reddy Gadi and Smita Thakkar.
Insurance company.
no representation for the appellant. 15/11.
Item 56, Damodar Mundra and K. Ravi Mahendra.
Sir. None appeared at 12.
Item 57, Ananda Dasari.
Hey, you look sir in that file. Get the beaches. Thank you.
Item 57.
No representation for the appellant. 15/11 and they have for dismissal.
Item 58, Suparna Mahendra and Dira Vijay Kumar K. Shashidhar Gaur.
After the appellant is at this time for 3 weeks. T8
Counsel for the appellant sought 3 weeks time to advance arguments. 29/11.
Item 61 and 62 adjourned. Item 63, Dr. Kadiri Krishnaya and B. Narasimha Sharma.
The request is made on way of the counsel for appellant. 15/11.
Item 64, R. Virender Kumar.
for the above argument. So we have not press this appeal as the suit in lower court was agreed party and a scheduled property it was noted that it's a self-acquired property of A1 mother. And mother subsequently
D1.
respondent number 1 died. Mother died. So the plaintiff is having again equal right in the property, then file a separate partition suit for the scheduled property. We want to not press this.
You are not pressing the suit appeal.
Yes.
Counsel for the appellant is sought permission to not press the appeal. Nine 11.
Item 66, B. Pramay Chaudhary and T. Mahendra Rao. On itself.
None appeared for the appellant. 15/11 dismissal caption.
15 days.
Item 67 adjourned. Item 68. B. Mayur Reddy and K. Venkatesh Gupta.
Then appeared for the appellant. 2911.
Item 69. L. Sushman Reddy.
Unappeared. 1511 under the caption for dismissal.
Item 70 adjourned. Item 71. Jitsuda and Shyam S. Agarwal.
May your lordship, please.
Yes.
This is the first appeal coming before your lordship. Kindly grant 3 weeks time for arguing it, madam.
Counsel representing the appellants are 3 weeks time. 2911.
3 weeks, your lord.
2911.
Much blessed.
Item 72. T. J. Jayasuriya and L. M. Kadri Raju. T. Anand.
71 appellant. 3 weeks is. Yes.
So the respondent counsel, my lord, Mr. L. M. Kadri Raju.
Appellant.
T. J. Jayasuriya.
Unappeared for the appellant. 1312.
Item 73. G.K. for appeals and M. Hamsaraj.
And as per direction of the mailers, the order lodging, conditional order pass has been passed lodgings. 50% deposit may be added. After that, amount is also deposited lodgings. May pass on lodging.
Not deposited, that I may permitted to withdraw.
Don't have any objection. Counsel for the rest.
Stay may be also.
ఎవరికి అది ఇచ్చిన Yes.
Item 31, the other side, compromise talks are going on.
31. 31. వెనక్కి వచ్చారు పాస్ ఓవర్ చేసామా
The conduct delay petition is there, because the compromise talks are going on the other side. But have it up to 10 days so that we can report it.
Sir, you are for respondent.
Yes. I am the appellant respondent.
What about condone delay petition? We don't have objection. Request of both parties. 2911.
29.
What is your date? Give me your convenient date, sir.
5th of December.
512.
For courthead matters, item 74. K. Buchibabu and R. Nagarjuna Reddy.
Last time also you are not ready. Request of respondent. The previous date also you start time. 1511. Time అడగండి అడిగిన క్లోజ్ చేసేస్తాం.
Item 25. EVS Ravi Kumar.
Hospital. TSHC Ravi Kumar. What are the accident and after?
Shrutakirti or
Yes, ma'am. Yes, ma'am. Yes.
No representation for the appellant. The court is informed that Mr. UVS Ravikumar is
Item 76, Bhagatwal Mandani and Nobu Sisters, the lawyers.
very
I beg to represent respondents number 2 and 3 who are given at 2 and 3 in the state. I seek my lord's indulgence to make a submission that the suit claim is resisted on 2 grounds by the defendants. Because the plaintiff has laid the suit on 2 appendages. One is that they have produced some documents before the honorable court, trial court. In that these are the documents under which some monies are paid by plaintiffs to D1 to D1. Monies are paid by plaintiffs
by way of investment
to D1. And these payments are by way of deposit. That is the claim. Because they have invoked the provisions of the Limitation Act to say that the amount is deposited. It is not a financial advance or loan. It is a deposit. So the cause of action arises when the deposit is requested to be repaid. A demand is made to refund the request, taking recourse to the Limitation Act. That particular plea is raised. My lords may see paragraph in my paper which I have given just now, preparing all the papers. Page number 17 is paragraph 9 of the plaintiff. That since the suit is filed for return of the amount deposited under an old agreement, like plaintiff number 1 with defendant number 1, as per Article 22 of Indian Limitation Act, limitation for filing the suit is 3 years from the date of demand made by the plaintiff for return of the amount. That since the first oral demand made by the plaintiff number 1 on 1/12/2007 and got issued a legal notice dated 12/12/2007, the suit is filed within a period of 3 years from the date of demand. This is how the cause of action and limitation is brought before the trial court. Now, what are the instruments under which deposit is made? I am talking on first appendage of the suit claim. The first appendage of the suit claim takes my lords to 3 exhibits, my lords. There are 3 letters filed by the plaintiff under which the alleged payments are made. I apologize to my lords, they are in Devanagari Lipi, but they are basically in Marwar. Rajasthani Marwar, I broke my head to understand it. I have sent it to 2-3 Marwadi gentlemen. It is in Gulsurat, so they did not decipher it.
What is the language that is used?
It is Marwar. It is Rajasthani Hindi, where more problematic is they have used that chain writing, like we do in Telugu. However, I made an effort to translate it from 2-3 sources, and I would like to make submission on that. The first document is at page number 52, my lords. So, my lords could see the first letter at page 52 is alleged to be written by D1, my lords. Am I reading it, my lords? I would read it because this is in India, I can read. श्री ओम प्रकाश जी अटल हैदराबाद रायचूर से पीएम राठी का जय गोपाल आज यहाँ से विनोद कुमार गोटी को तुम्हारे पास भेज रहा है सो उन्हें 5 लाख रुपया दे देवा. So Om Prakash is sending somebody there to collect 5 lakhs from Hyderabad. This is what is the request letter. Evan's request to this Om Prakash ji Atal, he is apparently the plaintiff number 1. And my lords would note that this is on a letterhead of a company, Pankatlal, Motilal, Rathi and Company. What is this company doing? Now, this is in Hindi, so I could make some effort. The next letter is in Marwar. I may be pardoned if I unknowingly if I say it is Marwar, but it could be some language dialect of Hindi practiced by Marwadis. I tried to read it. Sriman Om Prakash ji, Giridhar Gopal ji, Atal, Hyderabad. took out some writings from this. लिखी रायचूर सो PM राठी एंड कंपनी का जयगोपाल बचनाजी उपराज आवारी टपालनु सो देवानाजी आपके 300 रुपया 5 जमा किया. This is also again from Om Prakash. There is a difference in handwriting. My last mistake.
You are referring document dated 22/11/95.
22/11/95. After this 3/11/95. 3/5/95. My lords could see this 22/11/95. This is second letter. Now my lords, the third letter. Om Prakash Rathi Atal ji Hyderabad वाले के पास आप दोनों के पास 1395 and 22/11/95 आया चक्रा सामना अपना 4 साल के पहले 10 लाख रुपये दिया है. जका रुपये हमारा पास आपके बाद मेरे पास आने के बाद आपको आप लेंगे. मेरे पास आने के बाद आप लेंगे. This is the third letter. Now in this letter the peculiarity, my lords may see, again it comes under a letterhead of that whatever company is there. Top date, my lords may see, written in there are interlineations and corrections. Then bottom, my lords may see, there is a date. Now, to my understanding, my lords have records, original records. My lords can see whether the ink is same or not. Now, these are the 3 letters primarily based on which an amount is alleged to be forwarded, requested to be forwarded by D1 from plaintiffs, and plaintiffs give the money. My lords would see all these 3 letters are in the nature of requests or assurances to the plaintiffs. They are not letters from plaintiffs. Now, my lords, there are 2 ways we ensure the financial advances. In the normal course, we take up the promissory notes and receipts. Promissory notes are executed by the person who is borrowed. The receipt is also executed by the person who is borrowed. The person who is borrowed with sufficient stamp duty on that. Now here, this is one way of doing it. The other way of doing it, as claimed by the plaintiffs in this case, if there is a financial advance by way of a deposit, how far it is permissible in law in view of the Prevent Protection of Depositors Act, who can take deposits is a different aspect. But if a deposit is made, at least you expect a 100 rupees agreement, whereunder first party will advance monies to second party, and the second party will return the monies after as and when the first party requested with certain conditions. Now, these letters do not compose either of them. They are loosely worded letters of communication. What would be their impact for the suit transaction is the first question. Now, then there are interlineations, and my lords may take into consideration the fact that the emanating point, the first point of time is 95, May and November 1995. Yes. And we end up in year 2000. These dates may be noted because it's not basically my concern, but we have been tracked to the court, so we will definitely make a submission for this court. 2000 is the next set of letters. Now, first of all, whether these documents constitute a financial transaction between a borrower and lender, or a depositor and a depositee, is something that the court has to consider first. If that context comes in, then the plaint averments paragraph 9 sets in. Now, my lords, this is how he laid the suit. So my basic plea was this suit is barred by limitation. You filed the suit in the year 2009. If it is a deposit, it would have been worded in that manner, saying that I have taken this deposit, I will pay you so much of interest. Because his plea in the written complaint is that he has given that money because he was uncluded of high interest rate from the plaintiff. So there should be a in return, this is the interest I pay to you. But there is no such thing. And the suit is laid in 2009. My first plea that was raised before the trial court was that this suit is barred by limitation. So there is a second appendage of claim. I will come to that later. In between, what happened, my lords? During the trial, the plaintiff's witnesses PW 1, 2, 3, 4 were examined over a period of 1 week. exactly during that period, D2 was the youngster who was looking after the things. D1 is the mother, D3 is the mother. He was in Australia. His brother was in Australia, so he went to Australia. And cross was treated as well. We filed, after his return, we filed petitions to reopen the cross. And costs were imposed, about 2,000 rupees costs were imposed in each petition. We paid the cost. The biggest thing that had happened, because this is one thing that I've noticed in this transition from manual ADD to e-ADD. E-courts, it would show, the status would be shown that call with IS. We have noted down that in e-courts. So we came on the day when the matter is posted, call with IS as per e-courts. When you go there in the evening and see call with IS, if orders are passed, IS are already dismissed. Previous occasion, e-court and the petitions were allowed, and compliance, it was posted for the next day. That is not reflected in e-courts. And by the time in the evening when we noted down the day, these IS are dismissed. Immediately, the next day we filed petitions to restore them by depositing the cost. As per the earlier direction, we have deposited the cost and filed petition to restore the orders. And we have filed the proof of his travel to Australia, return back everything. Unfortunately, trial court dismissed them. And the trial court dismissed them. It said, start your evidence straight away. No further time will be given. We are going in commercial courts. The matter was running before commercial courts. We filed CRPs before this court against the dismissal and continued our. We filed evidence affidavit of DW1, and DW1 was cross-examined at length. And then we argued the matter and the suit came to be dismissed. When the suit came to be dismissed, the appeal was not filed immediately. My lords knows condoned delay petition was there. Condoned delay petition was allowed. In the meanwhile, CRPs got listed up in the infructuous matter, saying that the main suit itself is dismissed, nothing survives. My lords Honorable Justice Kodandaram Garu has passed an order saying that as and when if requirement is there, the defendants can file petitions to revive them. CRPs are closed. Now comes the second appendage. In the second appendage, it is the claim of the plaintiffs that based on the previous three documents, a liability is created or amount is there which is liable to be paid to the plaintiffs. So plaintiffs requested the defendant and the defendants issued 3 checks. And those checks were presented, they were dishonored, and they have issued notices to the defendant number 1. And defendant number 1 gave a reply saying that I have never issued you any checks. These checks were obtained by you earlier illegally and the liability is discharged. Those reply notices are also a part of the record. My lords may see it is exhibit. I will not read the. My lords may see page number 69, my lords. And one of the replies. This is the reply whereunder they say we have not given you any checks in response to their notice. This is for the first notice issued by the gentleman denying the liability. Thereafter, after dishonour of checks, another set of notices came. My lords may see them at the notices issued are at page number 86. And then at 89, the check dishonour notice is there. At page number 89, check dishonour notice. Now, after this notice, they issue a reply at page number 92. This is a document filed by the plaintiff Millers. D1 never came before this court. Because I am dragged, I am contesting, D1 has not come. This is the reply got issued by, apparently by D1. And my lords may see second paragraph, this being the case, they had entered into a settlement at Raichur during which your brother so and so had settled the accounts for rupees so and so, and they and has got decrease in favor of my client and so and so, assigned to his in favor to the extent of only. Now there is a defense they have raised in that, saying that some money decrease which the D1 had obtained are assigned to him, and hence he is not entitled to present the checks. The checks are not issued in discharge of any liability. This is a reply issued by D1, which is filed on record by plaintiff. Now, my lords, the judgment of the Honorable Trial Court rejected the first proposition. The Honorable Trial Court said that as far as this court is concerned, that the three documents that are filed do not decipher any deposit or any money payable to the plaintiff. Hence, there is no money payable under those documents. So, my lords, second three checks that are there to the extent of 2,50,000 rupees each, three checks issued by D1. My lords have invoked section 118 presumption and presumed that these instruments are issued in discharge of a liability. Hence, I have decreed the suit against D1 for these three checks only, and dismissing the suit insofar as D2 and D3 are concerned. Now, this is the two appendages of the plaintiff claim. The third side, on the third appendage, the D2, D3 involvement is there. D2 is a widow, D3 is a widow of the natural brother of D1. The brother of D1, he has gone in adoption to another family and is settled down elsewhere in Yadgir. He is not connected to this family. And that those people are well-to-do in Yadgir. They are industrialists there, they are respected, and they have money. Now the plaintiffs have planned apart, probably even D1 is involved in this. D1 may be known to each other because you are natural brothers, so you will not ignore them because you are living in a short world, small world. But there are no business transactions, there is no property sharing or anything and there is no joint family as such. But in order to extort money from D1 or from D2, D3, they have been made party to this. This is our plea. My lords should see the plain governments on the last time I read to my lords. In page 2, para 2 minutes. In page 14 minutes. In my paper book, page 14. That the defendants are closely related to the plaintiffs. Keeping in view of the relationship, the first defendant being the eldest male member of the defendant's family, informed the plaintiffs that if the plaintiff deposits amounts with him, he will pay interest more than the bank rate at so and so. Keeping in view of the relationship and the offer made by defendant number 1, being the eldest member of his family, the plaintiff number 1 agreed to deposit amount with defendant number 1. I stop here. This sentence does not smuggle in D2, D3 in any way. There is no assurance from D2, D3 matters for any such financial transaction. There is no such. By own pleadings, there is nothing to do with us. Now I see the rest of the thing is money advances, etc. I am not going to it. Paragraph 3. On 1/12/2007, the plaintiff number 1 requested the defendant number 1 to return the amount deposited by him together with interest. But the defendant number 1 and defendant number 2 did not give any reply. I pause here again. When you have not even made a request to defendant number 2 and 3, there is no question of their responding to your request. This is oral request, my lords. 1/12/2007, according to him, is an interpersonal request where he made it to D1. And he says he made it to D2 also. D2 stays in Yadgir. D1 stays in Hyderabad. What is the modus? Plaintiff stay in Hyderabad. D1 stays in Raichur. What is the kind of modus operandi you have done? There are no pleadings. You cannot have request to both of them and both of them replying in one unison to you saying that we will not pay. So this is the second part, my lords. Now I come to the page number 3, in the page number 15 of the paper book, my lords. 4 lines from the top. That the first defendant, as an elder member of the family, has drawn 3 checks in the name of plaintiff number 4, 3 and 2 as follows. Here also there is no joint family business. No, my lords, I come to paragraph 4, same page bottom. Page number 15 bottom. That the defendant number 3 is the sister-in-law of defendant number 1 and defendant number 2 is the son of defendant number 3. That the defendant 1 to 3 are members of joint family as informed by the defendants to the plaintiffs. D2, D3 have no interface with plaintiffs. Nowhere in the earlier part of the plaintiff, my lords. Here he said they assured that the plaintiffs 1 to 4 sins are brothers. The defendant number 4 has drawn in the name of plaintiff number 2 to 4. Keeping in view of the fact that defendants are avoiding to return the amount deposited by the plaintiffs, and since avoiding process in the aforesaid criminal case, taking shelter of honorable court for recovery of the amount due by the defendants. I already read the paragraph 9 minutes. Paragraph 9 relating to cause of action. Basically, this is cause of action and limitation, though it is not mentioned as. My humble submission is that in order to tag along any liability to D2, D3, the first and foremost thing the plaintiff has to establish before this court is that D1, D2, D3 constitute a joint family. There is a HUF with all the 3 defendants together. He has to establish that first. And then he must also establish before the honorable trial court that the financial advances made by the plaintiffs are to the HUF. And the HUF has received the monies, and HUF has assured that return of payments. My lords, I have already shown the letters. On the letterhead of D1, his own proprietary. I will come to that also. This is the letterhead of D1. It has got nothing to do with D2, D3. My lords may see the plain cost statement at page number 13, my lords. Page number 13 of the paper book I filed. My lords, my description of defendants. D1 is Raichur. D2 is Yadgiri. It is Yadgiri, not Yadgiri. It is Yadgiri. Next is also Yadgiri. My lords, so they are not living together. They are not at one place. Say that there is joint family living together. Now I seek my lord's attention to the checks. The checks that are filed before the court. At page number 84, my lords. 78 is the one check, 84 is one check, 72 is one check. There has to take for 72 minutes. Page number 72 is the check. My lords may see at the bottom of the check at the place where the drawer signed for Bankatlal, Motilal, Rakhi and co-proprietor oblique manager. This is not HUF. It's a proprietary concern of D1. Similarly, the same kind of seal my lords would see even in the next check also at page 78. Same is the other check also. So, in order to say that there is, first of all, you have to establish joint family. Second of all, you also establish that the transaction is made with the joint family. And third, you have to also show before the court that the checks are issued on behalf of a HUF account. Then only there is any question of consideration of D2's, D3's involvement in the suit transaction comes across. No, my lords, in our written statement, on the last occasion I have pointed out to my lords, a reading of the written statement would show clearly that I have averred. The written statement is filed by the son who said that my father has gone in adoption to Dev Kishan Rathi, and I am born and brought up there. We have Rathi is the surname, both in the same family. Rathi is the surname, but that's another family. This is another family. So we are not concerned with the D1 anymore. They stay in Raichur, we stay in Yadgir, and the adoption is done according to law by following the due process. We have mentioned these things with us. When we find a petition to receive the adoption deed, unfortunately, trial court felt that there is no averment with respect to the adoption in the written statement. Adoption deed in the written statement, and dismissed the petition. My lords may see at page number 103 minutes. This is the order, my lords. In the written statement, there are pleadings saying that the father of D3, husband of D2, has gone in adoption to Dev Kishan Rathi, and he was adopted by Dev Kishan Rathi at page 5, my lords. The petitioners, 1, 2, 3, 4 lines, 107, page number 107, 1, 2, 3, 4th line, my lords. The petitioners are the different 2 and 3, even though they have taken the plea that the father of D2 has gone in adoption to a different family, having adopted by Sri Devi Kishan Rathi under a valid adoption and procedure in their written statement. They have not made any reference with regard to the document. The objection of the trial court was that I have not given the document, I have not averred with respect to the presence of a document, and the procedure of adoption I have not mentioned, hence the petition is dismissed. My lords may now see at page number 109, my lords. This is the certified copy of the adoption deed filed along with the petition, my lords, obtained from the sub-registrar's office. I have also filed a photocopy because they could not trace the original deed. It is probably stuck in some income tax files, could not be located. At page number 113, I filed a photocopy of the adoption deed with all the endorsements. 113, 114, 115. This document is there in front of them. This document is filed by me. If it is the plea of anybody that this document is fraud and fabricated, the moment anybody raises a plea that it is a fraud or forged or fabricated, it is for them to prove. Insofar as I am concerned, I have brought a document, I filed it before the court. It is a certified copy of document. I have done my duty. Unfortunately, if the court wanted to shed its eyes to it, it is a misfortune for the plaintiff as well as me. Now, my lords, what happens? If it were to stop there, fine, my lords. One, after the dismissal, things went very fast, my lords. We had to argue the suit also. We argued the suit. Suit got dismissed. That's why we kept quiet. We did not file any revision against the dismissal of the for not receiving the document on record. Now I seek my lord's attention to the trial court judgment. Issue number 1 to 4 are answered at paper book 7 to 10, my lords. At paragraph 13, page 8. Am I saying it, my lord?
Yes, sir.
It is to be noted that the plaintiffs has to prove that the plaintiffs has paid amounts to the different number 1. The different number was set ex party, and the plaintiffs got filed exhibit A1 to A3, which show that some money transaction took place, but there is no recitals that the different number 1 agreed to pay 30% interest rate per annum, and he received rupees 10,000 as loan. My lords, may pausing here for a moment, may look at the issue. If somebody pleads that he is expecting 30% interest and advanced finances to somebody, I have an apprehension that it gets hit by Usurious Loans Act also. Whole transaction is negative. Apart from that, all the documents clearly show that the different number 1 not borrowed any amount on behalf of the family. There is a clear-cut finding. Even in the agreement of sale, an agreement of sale is filed with respect to some property, saying that that agreement is executed by way of security. If you had to invoke that agreement, you would have filed a suit for specific performance or recovery of money in the appropriate court. No such step is taken, my lords. Even in the agreement of sale, an amount of rupees 12,50,000 as money transaction between Rajalakshmi Coimbatore and BM Rathi and Company and associate firms, but there is no mention that the different number 1 has borrowed the amount from plaintiffs and the said sum amount is adjusted under the agreement of sale. Therefore, the plaintiff has to prove that the different number 1 being the head of the family has borrowed the amounts and the different number 2 and 3 are jointly severally liable for the same. The documents filed with the plaintiff itself shows that the different number 1 has not borrowed any amount on behalf of the family. Even as per exhibit A1 to A3 also shows that the amounts has to be given to some aides, but it was not a loan. Here my would have mentioned the names also, because probably we didn't have the time to file the translations. Plaintiff did not file the translation. 2 names I have read before, my lords. One is Vinod Kumar Bhoi and some other name. 2 people have carried the money, gave the money, brought the money, or whatever it is. It is not these people directly exchanged the money. That is what the trial court is restricted. Given to some X, but it was not as a loan. Apart from that, recitals of the agreement of sale shows that an amount of rupees 12.5 lakh was adjusted in between the two forms, but not two individuals. Therefore, any of the amounts you referred under Exhibit A1 to A3 cannot be said that the different number one has borrowed the amount from the plaintiffs. The first appendage is snapped here. Any kind of reliance on Exhibit A1 to A3 to show that there is a financial advances has snapped here. It's collapsed. Now, it is also to be noted that the different number one set expiry. Apart from that, the plaintiffs contended that the different number one has issued 3 checks as a part payment, but there is no endorsement or acknowledgement that those 3 checks were issued towards the past debt. Therefore, the plaintiffs have miserably failed to prove that the different number one has borrowed the amount from plaintiffs, and the plaintiffs have invested the amount before the different number one, as he is going to issue more interest than the public bank. This is how the Honorable Trial Court cut the first appendage pre-minutes. Now the second thing comes. The plaintiffs got filed 3 checks issued by the different number one. Those checks were issued in the year 2008. It is the bounden duty of the different number one to prove that under what circumstances those 3 checks were issued. Now here, my lords, the line of evidence that goes for a civil dispute and for a 138 proceedings vary a bit. The common meeting point is 118, my lords. So the assumption, the presumption in law for the trial court was the entries in the 3 instruments are correct and the 3 instruments are issued for consultation. To that extent, it is okay. And that is done by Om Prakash ji. So Om Prakash ji is answerable. Then the trial court went on to decree the suit based on those 3 checks only to the extent of 7.5 lakhs with 6% per annum interest, which normally the courts grant while granting a money decree. No, my lords, there is something very reasonable here. For instance, if this is a collusive suit between D1 and plaintiffs, definitely there was an endeavor to push me into this transaction, to pressurize me and take money from me. Because these words go in the market very fast. The small world, people know that there is a suit filed against them. So these people money is able to be paid. That was the basic endeavor that is done. Now, why I am trying to read all these things? The Honorable Trial Court has rejected the theory of advances, financial advances, at higher interest, deposit, all that things. The court has rejected. Only based on the 3 suits, the suit is decreed. When that theory is rejected, the question of joint family involvement, D2, D3, it does not come anywhere, my lord. Totally preposterous. Now, I don't want to burden my lords reading through. I have read my written statement on the first time when I argued the matter online, my lords. I seek my lord's attention by going through the readings to go through the written statement once again. But what becomes most important is, even this also I would not read it line to line. The cross-examination of D1 by plaintiffs. My lords, while doing cross-examination, we all know, we all try to make an endeavor to bring in facts. Facts which you deny. For example, you deny that the father of D3 or husband of D2 is the natural brother of D1. They are living together. They are having common kitchen, common business. They are being a joint family. They are together in debt and in profit. If that is your plea, and it is your plea that the theory of adoption, everything is fraud, is false. What should be the line of cross-examination? Well, also may see at page 47, the cross-examination begins. And it runs into 4 pages. And I leave the first page, my lords. I take my lord's attention to second page. In any case, the record is, I have filed it myself. Plaintiff have not filed it. I filed it. I want my lords to read through. Because this is, D1 is the only person who is cross-examined. All PW 1, 2, 3, 4 evidence is based on their chief. There is no cross. I could not cross them. There was no cross-examination. If I were to cross them, probably I would have done better service to the case. I didn't do the cross-examination. But D1 has been put to cross-examination. So plaintiff has done service to himself. Now, my lords may see at page 48. I have filed, second paragraph, my lords. I have filed registered adoption deed dated 1/5/1971 before this court. I have not filed any other document or evidence before this court. It is not true to suggest that the alleged registered adoption deed dated 1/5/1971 is a fabricated document. It is not true to suggest that I have not filed original registration deed 1/5/1971 along with the written statement, as it is a fabricated document. It is not true to suggest that there is no mention about the registered adoption deed date 1/5/1971 in the list of documents of written statement, as the said document is fabricated. This suggestion is made to him in the face of the pleading that the deed 3 has pleaded that my father has gone in adoption with then Mr. Rati and he has been living separately. He has got no joint family with D1. There is a specific averment in the written statement at least 3 places. In the face of that averment, this allegation is made. Now, if you make this allegation, it is for you to prove because the document is resisted. They resisted my petition, my lord. They could have said subject to admissibility, proof and relevance, it be received. They had every liberty to prove it as false or forged. He opposed the very receipt of the document. But in the face of that, they make these arguments. And then, even in the next page also, the entire suit transaction is questioned to the defendant number 2. He has given that answers to the questions and say that we have got nothing to do with this. So my humble submission is that the plaintiffs have miserably failed to show that there was a joint family between D1 and D2, D3, and there is any obligation cast on D2, D3 to discharge the liability that is alleged to have created by D1 on one angle. Secondly, my lords, this plea was raised. We opposed the suit because we are law-abiding citizens. We don't leave things. We don't ignore court summons. D1 may have the habit that is his headache. When we resisted the suits, the Honorable Trial Court gave a finding that there is nothing to do with D2, D3 and dismissed the suit. Actually, the Honorable Trial Court ought to have granted us cast. The Honorable Trial Court did not grant cast, we left it there. Now the appeal has come before this court. At least in the appeal, we ought not to have been dragged again. We ought not to have been dragged again in view of the findings and documentary evidence. In spite of that, again we are brought to the appeal because again we are the golden goose. Only we can give X, D1 will not give X. So my humble submission is that neither the checks have anything to do with us, nor Exhibit A1, A23 have anything to do with us. The entire suit transaction is a hocus pocus and in fact stale and barred by limitation. The thin line on which it is surviving is the presumption under section 118. Even for that, if I look at its civil liability, in the face of the reply notice from D1, I'm not arguing the case for D1, but I am putting up a legal point with us. D1 has given a reply to the 138 notice. He has given a reply to the suit notice saying that I am not liable to pay you anything. There is some settlement done. We are misusing the checks. My assumption in law is that 118 gets shaken. The court has to examine, even if it is a ex parte, it is for the court to examine whether this check is issued. No such thing is done by the trial court. Trial court felt that because D1 was set ex parte, he did not come forward and did not lead any evidence. The suit is liable to be declared. It is his headache, not my concern. What I am trying to submit is that in view of the replies got issued by D1, suit becomes barred by limitation. There is no connecting link to any liability to these 3 checks. In such circumstances, the responsibility of the plaintiff is more onerous. He has to bring in evidence before the court because he has already filed the replies. Vinod Kumar Goti is not examined before this court. All 4 plaintiffs are examined. The remaining 2 gentlemen who are named in those documents, they are not examined. And it is not pleaded in the plaint that there is any other monetary transaction for which those 3 checks are issued. It is the plea of the plaintiff that these 3 checks are issued for that transaction. When you say that, the transaction has become stale. 2000 transaction becomes stale in 2003. You come with 2007 checks and file a suit in 2009. How do you connect them? There cannot be any acknowledgement of debt. It is a time-barred debt for which nobody will issue checks. So there is some amount of evidence that was required to be brought before the court, which the plaintiff has not brought. If the trial court were to look at it in a very critical way, probably even that 7,50,000 degree also would not have been granted to the plaintiff. In any case, we should not have been bothered. Now that we are brought over here and made stand before this court and make submissions, the appeal is liable to be dismissed against us with costs all through. That's my appeal.
Any reply, sir?
I'll argue today. Only 2 decisions I will pass on. Tomorrow or anything. If you also want to ask tomorrow,
Will it be okay tomorrow?
No issue.
Tomorrow for continuation.
All these things I can
But
only.
council for the rest. Next.
Item 77, Rubella, Mahinda, and Srinivas, Simla, Mallapur.
Hearings for the applicant. Your lordship had called for the report.
Records will change. Not yet received, sir. Await records. 29/11. Registry is directed to issue a reminder. 30 maybe holiday. Election date, I believe. Will be declared as holiday. 1/12. No problem. 1/12.
Item 78 to 80, Mr. Virender Singh and yes, Srinivas.
Today morning they have served the copies, the amendment copy. Like I counter on that, what should we take it on?
Lord, I have filed a formal application for amendment. What my friend senior counsel said, he has no objection. But anyway, my lord, let it be had on Monday, my lord. It's only a formal application.
With your lordship's kind permission. With your lordship's kind permission. No copies have been served on us, your lordship.
No, we have sent you by mail. Anyway, we'll send it once again. Lordship will put it to Monday, my lord.
Monday holiday, sir.
Tuesday.
Tuesday.
Your lordship may post it after 15 days. Your lordship will have to file counter in this.
No, it's only a formal application.
No formal application. Your lordship says morning they file, it is numbered. We have filed a CD long back. No copies being given to us.
No, it will be given to you. Only then it will be numbered. My friend may not worry about it.
15/11.
Going through, if he requires, let us see.
Council, Mr. (15/11).
Your lordship may say, let them serve hard copies, your lordship. No copies.
Yes, we'll do it. We'll do it. I'll see to it that it is served in your office this evening.
Okay.
Item 81, Kalapur Srinivas Rao and Krishna Kishore Kovuri.
You are for APSRTC. Who is for TSRTC? Srinivas.
One of these.
A Srinivas.
Yes, Adilabad, Srinivas Reddy.
A part of TSRTC or entire TSRTC?
Part of TSC.
మీరేమి ఏమున్నాయి?
Sangareddy,
Adilabad.
నోట్ చేసి పెట్టుకోండి.
చెప్పండి, ఏ శ్రీనివాస్ రెడ్డి.
అదే ఉదయం చెప్పింది ఏ శ్రీనివాస్. రైట్.
Case of injuries, my lord. The claim is 4 lakhs, my lord. Award is 3,89,000. The evidence of the driver was also adduced, my lord, but.
You have already argued.
Yes, my lord.
Who is for responding?
The respond is that.
No, I heard the counsel for the appellant on 4th October. Two adjournments. Request of respondent counsel. Tomorrow, sir. మీరు ఉండకపోయినా పర్లేదు. I'll hear and okay. ఉంటే మంచిది.
81.
Yes.
Item 82 and 83. G. Ravichandran and T. Natraj.
82. Said inform that you want to take time to
I have no urgency. 22 appeals కాబట్టి if you both of you are ready, I'll hear. Otherwise,
you may have some time next month.
Okay.
item 84, Ashok Kumar Agarwal
చెప్పేసాను మళ్ళీ ఆయన వెళ్ళిపోతాడు. I'll wait for.
and A. Suryanarayan.
Thank you, Your Lordship. Opposed to my earlier submissions, Lordship, I can be recollected that the fraud has been deliberately exercised upon the plaintiff, who has taken a new hand loan of 7 lakhs from the days of mortgage deed, registration of mortgage deed.
Save on time.
Defendant number 2 by paying fraud upon the plaintiff got executed and registered an agreement of sale. Basing on that, a counterclaim has been placed before the court below my lab. My suit as well as a counterclaim were dismissed as against the same CC is taken. And as against my dismissal of my suit, my lord, I will appropriate appeal before the court below is in the process. On the last occasion, my learned friend has submitted the citation of Karnataka High Court, quoting that this is exactly on the similar lines, wherein the suit for specific performance was decreed by the court, my lord. In this, my lord, my learned friend has taken your lordship's kind attention from
Citation was
Para number 17 onwards. 17 onwards, and stating very selectively as read the paragraph to your lordship to file suit is requirement. After going through the contents of the citation, I came to conclusion that the facts which are stated in the decided in this case, my lord, are quite different and distinct, except one allegation by the defendant that the fraud has been exercised over her, being an old lady, illiterate lady. She was taken to say that a joint development agreement has been going to be executed. On that pretext, she has executed an agreement of sale. Except that particular aspect, my lord, nothing was there on record to connect anything from this judgment to the present case on hand. Lordship may kindly see in the opening citation in the suit.
అదే
My learned friend has
తీయడానికి లాస్ట్ టైం వేశారు.
Karnataka
అన్ని అపిలెంట్ వేసినాయి అన్ని
అప్పలెంట్ పేజ్ ఆయన అప్పలెంట్ వేసింది.
అపిలెంట్ అయినా సూర్యనారాయణ గారు respondent.
అటు ఈవెంట్ నేను చెప్తాను.
Yes,
ఎస్ ఇది
Lordship may kindly take paragraph 4 to ascertain the facts of the case on. The defense of the defendant was as follows. Ownership of the property was admitted, but the execution of the agreement, receipt of the amount, request of the plaintiff, and issuance of the notice were disputed. The market value of the property was not the cause of notice. Daughter, son-in-law, and grandson are addicted to vices and alcohol. She is an aged, ailing, illiterate lady and belongs to backward class. Taking advantage of such a situation, some estate agent has taken her signatures, representing that the agreement is a joint development agreement. Therefore, the agreement is the outcome of fraud, misrepresentation, and undue influence. Thus, she sought for dismissal of the suit. During pendency of this case, my lord, the old lady expired, and her in-laws were brought on record as defendant number 1A to 1F. And during the pendency of the said suit, my lord, the in-laws named defendant number 1A to 1E filed a compromise petition at paragraph number 10 of the said same judgment. Under Order 23, Rule 3 of the Code of Civil Procedure 1908, before the court, in the said compromise petition, they admitted the execution of the agreement of sale. Initially, in their additional written statement, they denied the execution. And what transpired in between the parties, we do not know. Somebody, all of a sudden, they took U-turn to the written statement and say that they are compromised. And they admitted the execution of the agreement of sale and receipt of consideration of amount. Under the compromise petition, they considered for decreeing the suit of the plaintiff for specific performance and undertook to hand over possession of the property to the extent of their stay to the plaintiff. This is a case where they have taken U-turn and came to a settlement of compromise before the court below. One of the legal heads opposed the compromise and suit went on. Later on, the suit for specific performance was decreed in favor of the plaintiff. Whether may take last paragraph 36, my lord. Basing on the compromise, my lord, the suit was decreed. 36 paragraph. I have already pointed out, respondent number 1A to 1E have filed a compromise petition considering the case of the plaintiff appellant and to grant a degree of specific performance in his favor. Respondent number 1F opposes the said compromise on the ground that, along with the other properties in respect of the very same property, her suit for partition was pending. So, by sum and substance, the facts narrated in the case on hand before your lordship rendered by Honorable Karnataka High Court, my lord, those are irrelevant for consideration for the present appeal because the facts are quite distinct and different in our case. In my case, I denied the execution, I contested the case, and the appeal came before your lordship on the dismissal of the counterclaim. And surprisingly, on the very same day, both the agreement of sale and sale deed and payment of alleged balance consideration was said to have been paid to the plaintiff in the suit. That cannot be concurred, my lord. In all my respectful submission, the CCCI needs to be dismissed by this honorable.
Only one sentence I would like to say, because they have set up a plea, they have filed a suit, they asked my agreement of sale cum general power of attorney to be cancelled on the ground that it is vitiated by fraud. That cancellation is not found favor with the court, and the court has said that the cancellation cannot be done. There is no fraud, there is no collusion, there is no misrepresentation. You have clearly executed agreement of sale cum general power of attorney. Then coming to the counterclaim filed by me for specific performance of the agreement of sale cum general power of attorney, the court says that I have not issued notice to them as contemplated under section 16C of the specific relief act. Prior notice before filing of the counterclaim. As such, my counterclaim is dismissed. I stated before your lordships that the issuance of a prior notice, even as per the judgment, even as per the judgment which is referred to by the lower court, is not mandatory. In view of that, my lord, as there is no appeal which is filed by them in respect of their cancellation of the document which is dismissed, they cannot plead now that there is a fraud or collusion.
Now it seems they filed an appeal.
Yes, sir.
No, 1 minute. They have not filed the appeal before this honorable court. They seems to have filed an appeal along with a delay of about
whatever may be the delay. Now with the appeal, SR is pending.
It is
a delay of about 7 years. See, after hearing of the appeal before this honorable court, they have proceeded to service a delay continuation petition and filed an appeal in the Chief Judge City Civil Court, Hyderabad. My respectable submission is that under the City Civil Court Act, my lord, the appeal has to be filed before this honorable court. They filed an appeal in a wrong court, cannot say that there is an appeal pending before this before a competent. Lord, under the Civil Courts Act, I filed the appeal before this honorable court. Really, the valuation for both the counterclaim as well as the suit are one and the same. 9,45,000 rupees. I filed an appeal before this honorable court because at that particular point of time, 2017, when the appeal is to be filed, whatever the law which is there under the City Civil Courts Act, my lord, that would be applied for the purpose of appeals. Then the appeal has to come before this honorable court only. They filed an appeal in the Honorable Chief Judge City Civil Court, Hyderabad. No doubt, Honorable Chief Judge City Civil Court, Hyderabad is having jurisdiction to entertain the appeal now after 2022. But not on the date when the decree is passed. So as such, my lord, even if the appeal which is filed by them is in an incompetent court of law.
That my learned friend can agitate that issue before.
No.
But 1 minute.
For a particular purpose, is representing this. Right. I understand why you.
It says that the appeal is filed. There are no papers before this.
Wait.
It has been taken on file and it
delay condone application notice was ordered by the court below minor. And it is dated on 10/11 minor for their appearance and counter. So whatever that my learned friend has submitted before this honorable court, if I am wrong in placing the appeal before the court below, that will be, I will follow the suit, my lord.
Right, sir. 412 for judgment.
Actually, directs me to submit the certified copy.
No, why should I? కాదు బిల్ అంటే వేసిన ఆయన వేసిందే దాని మీద చెప్తున్నాను కరెక్ట్ ఎందుకని 412 సార్
పాస్డ్ అవర్స్ ఒకటి డిస్మిస్ చేశారు అది
ఆయన ఆర్గ్యూ చేసింది జమాలి కాలేదు కదా సరే ఆయన వస్తే వస్తాను ఏమంటే మీరు వెయిట్ చేస్తున్నారు నాతో కాదుగా ఏది లేకపోతే తీసుకో రంగా ఏమి ఇంకా ఒకటి ఉంది కదా రైట్ పర్వాలేదు
Present suit in this present CCC arises out of an judgment and issue US number 349 of 2006. So may I request your worship to kindly for a minute take the application, but more particularly the order of the page number 21. Frustration. Page number 20. But the plaintiffs, here the case is that the plaintiff 1 and 2 are the children of Kudus Ahmed. Kudus Ahmed had 2 wives. So these are the 1, 2, then from the side of the defendant, 1, 2, 3, 4, 5, 6, 7 are the children from the first wife. Then 8, 9, 10, 11 are the children from the second wife, the sons. And then my lord, defendant number 12, my lord, is Kudus Ahmed's brother's son. In the pleading and in the record that have there before this one. But in the court, he has been cited as a tenant in the property in which they sought partition. But in effect, what is stated by them in the plaint is that this gentleman Kudus Ahmed was the owner of the property for the partition. It is a property measuring 558 square centimeters for which partition was sought. But what is not stated by them, I'll demonstrate that this fact was suppressed by the plaintiffs as regards the title of the title with regard to the property. In the plaint, I'll come to that now. Just for factual foundation, I'm submitting to the that in the plaint in OS number 349, it is claimed by them that Kudus Ahmed was the owner and possessor of the property, implying that he had title to the property. He had title to the property. In fact, facts are otherwise, but as far as how they styled the aspect of title, they said that Kudus Ahmed had title to the property. On that premise, my lord, along with the paper, I had filed a judgment. My lord, in this case, one thing has happened, my lord, I have to clarify at the outset. For a minute, that same concept.
So appeal is by the children of the second wife.
By the first wife. By the first. The children first wife, second wife, that is not in dispute. But 2 suits were filed by the children of the first wife. Your Lordship, for a minute, take once again peruse the cost title mirror, the page number 21 cost title kindly mirror. The sons have filed OS number 349. The daughters, this daughter 1, 2, 3, and 4, 1, 2, 3, and 4 of Kudus Ahmed, they filed a separate suit for partition. They filed a separate suit for partition. That suit culminated in a CCCA before this honorable court.
When that suit was filed?
My lord, it is a contemporaneous filing, my lord.
Why both suits were not clubbed?
No, the suits were not clubbed. But what happened, my lord, is
was it brought to the notice of the court?
Yes, it was. Yes, my lord. I'm coming to that. So what had happened is, since the sisters had filed the suit and a full-fledged trial was conducted, it went up to trial. But at the time, my lord, once when they came to know that this present suit has been filed by the brother, it was brought to the notice of the court and a stay was given to the proceedings of this particular suit. This particular suit was stated because another suit, 248 of 2006, it is all there in the record. 248 of 2006 was also filed because that was an earlier suit. This was a subsequent suit. Following the provisions of section 10, it was stayed. Then what happens, my lord, is your lordship may kindly take page number 101 in the same papers, my lord. The order of this honorable court. My lord, I realize now that it should have been a full-fledged order copy with the cost title matter. Anyhow, many facts come out of this first. This is that the first suit that is filed. Your lordship would see page number 101. Order of this honorable court. This CCCA is held against the judgment and differentiated 3/2017. Passed in OS number 240 of 2006 before the journal 1036 in the Supreme Court Hyderabad. Said suit was filed for partition and public possession of the seized property and for grant of purpose and interest. Freely, the defendants from creating a charge or dealing with the property in any manner. The property in question in the suit
suit is a site at measuring 558 square yards along with building with bearing with door number 16-7-784 situated at Chadarghat, Agastpura, Hyderabad. The claim of the plaintiff in the suit that they are the children of late Kuddu Simon and his first wife. Defendant 5 and 7 are the sons of Kuddu Simon and the first wife. And the first wife. The defendant number 1 is the second wife of Kuddu Simon, and defendants 2 to 4 are the children of.
Of course, the first suit was dismissed on the ground that it is a for partial partition.
In this honorable court at that point of time took a view that it's barred by partial partition. The plaintiff in the suit has got all the property of Kuddu Simon. What they suppressed it, they suppressed will not record is there's a record to that effect. And after that, will not show. The 8th paragraph is also important. This paragraph number 8 will have to be seen in the context of the suit that somewhere in 2008, 2009, this particular suit was stayed. This particular suit and what went on for trial was that suit 248. The paragraph number 8. The CCCA is accordingly dismissed. There shall be no order as to cause. However, as the suit in OS number 349 2006 is pending, and the appellants herein and the appellants herein are also parties to the said suit, they are at liberty to set out the defense in the said suit, and the said suit is also for partition of the very same property. The mistake what has happened by the present appellant in this particular scene is, since there was a stay, even after this order, they did not file their evidence. Basically, I'm also after
when both the suits are for partition by the same
in respect of the same property.
They could have clubbed. They sought for clubbing of the both suits instead of obtaining a stay.
Yes, my lord. That
Perhaps for their purpose they must have obtained stay.
Thought it fit that stay would serve them.
Or for any other purpose they could have obtained stay. We don't know.
That what your lordship is pointing out. With that, what would have happened is for both the suits, it could have achieved a finality. So I would not have been here in this present CPC. But unfortunately or fortunately, that did not happen. What happened was the stay was given. Basically, my lord, I wanted to urge for remand. My lord, I have set out a ground in my affidavit also asking for a remand of this honorable court. Under an impression that the stay is there, after this 6 months thereafter, this particular suit is decreed, my lord. Under the impression of the stay that the stay has not vacated, that is what that is the reason why, my lord, I have filed a petition for bringing on record certain additional documents, which obviously we did not file there, my lord. The index of evidence is very clear that nobody was examined from the side of the present appellant, and obviously no documents were filed. That being the reason, if your lordship considers for remand, then I need not.
What is the ground?
The ground is only this. They stay in this suit.
See, they deliberately they did not adduce any evidence. Allowing them to adduce evidence after 10 years or 15 years, it is nothing but causing.
I would not say under an impression. Deliberately, I would.
We don't know whether it is deliberate or not.
At best, it came under an impression.
Even once they came to know that there is another suit, either of the plaintiffs could have sought for clubbing both the suits. There could have been a finality.
Yes,
instead of they obtained stay in one proceeding and proceeded with another proceeding, wherein there is no there is a specific government that there is another property shown in the other suit.
That could not have happened also for the reason. The suit, both the suit, the suit now before your lordship is by the son of the first wife, their own sisters. The second wife.
As per the judgment in CCCA, now you referred, it is very clear that it is brought to the notice of the court that only some property was shown in the suit, leaving the other properties. When once that is within the knowledge of the parties, either of the defendants are
Either of the children of the first wife
could have sought for clubbing both the suits so that there could have been a finality to the litigation. Why all this exercise? All right, now. What is the ground on which the suit was decreed partly? Decreed?
The court held that Kuddu Sarma had title to the property, notwithstanding the fact that no document of title in respect of Kuddu Sarma to this suitable property was filed.
No, suit is decreed.
Suit is decreed. That's why I am urging.
What is the difficulty for these two defendants, appellants now to accept this decree?
It is a work property, my lord.
It's a work property which was suppressed. It's a work property. This aspect was suppressed as of the point of suppression. I think a lot of on that point, it was suppressed, and it was said that Kudus Ahmed is the property. In fact, work property taken on lease. The nature of the property is it is now I have filed documents to the effect. Actually, I should have been filing there, but since we did not file it there, now we are there before your lordship with those documents. It's a work property which was taken on lease. That is the nature of the property. Only extent of the nature of possession can be looked into, but title is not there because there is an endowed property, work property.
Suit of 2006. Yes. Now we are in 2023. Appeal of 2019.
Yes,
What way these documents are relevant? Petitions, writ appeals. Suit of 1966.
1966, this established that this is a work property. Kudus Ahmed is a party to that suit. He admits that he is a tenant in the premises. His father was. He admits that his father was a tenant in the premises.
What is the present status of the property?
Present status is among the possession of the this party.
No. If they are real,
They are in possession of.
Then why they did not choose to appeal before the court to contest the appeal? This appeal, they denied the receipt of notices. The notices sent to the respondents 3 to 10 were returned.
Yes.
Unserved as not claimed.
Yes, ma'am. It is their choice.
Oh. We know why the parties kept quiet and why they tried to contest. If the property is in the hands of other parties.
At the first fight, children of the first fight.
Right, sir. Heard counsel for the appellate.
On merits, I can make.
Heard in part 7. See, we cannot revive the litigation of more than 20 years by sending the matter back to the court unless there are strong circumstances. And the parties deliberately kept quiet without bringing to the notice of the court about the other suit.
No, other suit it was brought to the notice. It was brought to the notice.
What is the purpose of obtaining stay instead of proceeding with the trial in both the suits? See, when the case is that there is some other property shown in the other suit. In general, it is quite natural for the parties to seek for clubbing both the suits.
Yes.
But in this particular case, they sought for stay. What would happen if the matter is stayed?
What the lordship is now observing is that my party is
whoever may be.
Obviously, it is as one. I do not have material, but it's obvious that the present set of appellants, that is the second wife's children, second wife's children. Instead of obtaining a stay or under 10, they should have asked.
So why I am asking all these questions is suppose if the party is in the hands of third or fourth purchaser or something like that.
No, that is not.
Something like that.
Yes.
It is giving a scope for another round of litigation without any fault of those particular persons who are in possession of the property. All right, I'll hear you on 1511. Upside and dismissal. What is your request? అదే మీకు మీరు మాట్లాడడానికి ముందు చెప్పింది అదే నేను.
Father, my writing 36 and 37. ASP Suresh Kumar and A. Malati.
నన్ను బెదిరించారండి ఆయన వెళ్ళిపోయినాడు. ఏమన్నా అన్నారు ఆయన్ని వెళ్ళిపోయాడు ఆయన. Where is he? 36, 37, 38 away కదా?
Yes.
36, 37 both are connected.
మిగతా రెండు against the same OP.
Only quantum, we asked for enhancement. I filed against the data, I am disputing with this.
Right, ఆయన ఆర్పీ చెప్తే మనం ఎందుకు హెడ్ బ్యాక్ పట్టుకోవడం?
Remaining two matters, 38, 39, that both the claims.
Here on 2911. 2911. ఆయన కదా సేమ్ పార్టీ, సేమ్ కౌన్సిల్ అదర్ సైడ్. 38 and 39 dismiss అయినాయా?
Both the claims dismissal will for that paragraph.
No, I know why he remained absent. Might not have received instructions from the party.